Yes.
May I place your Lordship?
Oh.
Lordship, with respect to item number 14, Lordship, I have sent a letter yesterday to the accused. Verify whether the accused is alive or not, as because his mobile number is showing not in service, Lordship. That case has been listed after almost 7 years, Lordship.
Did you ever try to get the case listed at any point of time? Did you personally try to get this case listed at any point of time in the last 12 years? Let the matter reach, we'll see.
Your Lordship.
Huh? Mr. Ekedas. Kekolita, learned counsel for the petitioner, submits that during the pendency of the present, when do you have the date? No, date. Had passed on, on 8/8/2021. Accordingly, submits that the present revision petitions stands abated. Full stop. Prayer is not objected to by the learned counsel for the respondent. In view of the above, the present appeal stands closed on being abated. Not today. No. All listing. Give it. Only if it is not for today. If it is for today, make a mention.
Item number 12, Lord.
Hmm.
This Lordship.
You don't have need the record. You be here. Take the record, read it. We'll help you. That vehicle, 40 kilometers per hour. The MVI report you have seen. Make your submissions. What is there? Rash and negligent has to be proved, right? Prove it. Whether it is established, not established, you are entitled to an acquittal. If it is established, you are entitled to that. Just that point only. Two, I think the MVI's evidence and the evidence of the passengers are, one passenger has said 40 kilometers. Just go through the records. We'll take it up. Why keep it pending? Just a moment. Your item is Mr. 4. What happened is I've told Mr. Bora yesterday. I received a call from a very old friend of mine. He said that this lady happens to be his cousin sister, and I knew her also when I was a young guy. So I think I should not be taking up this matter. I'm releasing this. I don't know why that call came, how it came. Be that as it may, I was ready with the matter. Otherwise, I'm releasing it. The learned counsel for the registry to list this matter, item number 4, before any other bench without me, Namtu Didivar. I'm sorry.
Awesome.
I beg to mention a listing of a Lordship, there is an urgency, Lordship, as the trial court case is fixed before trial court on Saturday, Lordship. Friday, Lordship.
Yes, item number 8. Why?
Bishop Senior Counsel is in another. We are otherwise ready with our arguments. We argue today. Accommodation is sought.
How long will it take? 11.
11:30.
11:30. Ma'am, can't help it.
Obliged.
Last queries that your Lordship placed, that on PW10 has stated that there should have been 17 question papers, 16 were recovered. Unless seizures prove, there is nothing to which seizures were proved. Only thing that material exhibit 1, that is the requisition which was signed and proved for my entrustment. And I have gone through the certified copy of those requisition material exhibit 1, which shows that a requisition was only 15 question papers for requisition, my lord. This is, my lord, I have got the certified copies. And moreover, my lord, as regards the, my lord, quantum of entrustment, it has not been proved. Neither they have proved through the register how many question papers were delivered to the alleged accused. And moreover, my lord, the statement that there was a leak in this of the question paper outside the school, that is only under hearsay. And that was neither, my lord, if I go through that judgment in the particular place, my lord, if your lordship finds at page 15, not 15, my lord, in page 14, my lord.
See the evidence of PW 12.
PW 12, my lord. Saibur Rahman supporting the testimony of PW 10 and 11
No,
deposed
no.
that during
You come to the evidence of PW 12.
evidence, my lord, evidence.
Have you gone through the evidence of
No.
PW 12?
They are unique.
That is with regard to the holding of the examination or not holding of. Ah,
But my lord, they have, the burden lies on
okay,
the
you read 12.
12, my lord. Well, my lord, my friend will read it because it's very difficult to read. এই পক্ষ চিনি পাওঁ 2000 চনৰ ঘটনা ক্লাছ 9 বোৰ্ড এক্সাম আছিল মই আমাৰ চেণ্টাৰৰ অফিচাৰ চাৰ্জ আছিলো
So here the entrustment is proved. Okay, number of is not proved, but the entrustment is.
I'm not denying that. Numbers is not proved. And my lord, the material exhibit on the basis of which it was entrustment is proved, it says that my lord, only 15 requisition was 15. And the my lord, leak question of a leak is proved in that way only by a hearsay. That chapter, my lord, that particular portion, my lord, your lordship will find the judgment. My lord, page 12. Page 12, my lord, the paragraph starts from corroborating the testimony. Page 12, my lord, your lordship may got it. Corroborating the testimony of PW 10, Ramkrishna Talukdar, who has been examined as PW 11, deposed that he was a member of class 9 board examination, Borpeta Road, in the year 2006. He stated that the accused is the headmaster of Karaguri Anchalik High School. It is deposed by him that the information that question papers for class 9 examination got leaked out near accused school. And he got this information from the headmaster of Pohumara High School. This is Pohumara High School, my lord, headmaster is not a witness. And this is only a hearsay, my lord. Section 60 of the Evidence Act will come back.
What made you take the question papers when you never had an examination being held in this school?
My lord, but whether,
That is a circumstance which goes against you.
my lord, but my lord, I
But the
myself-
evidences are there that in that school there was no examination for past many years,
but
no
that-
students.
but my lord,
That shows your criminal intent.
but my lord, does it show that, my lord, only by entrustment it will not prove that I have
No, the very entrustment is by way of
material
deceiving the
exhibit
people.
one requisition, by my requisition.
Why did you do that?
My lord,
When you,
because after I got the requisition, my lord,
no, why did you first?
But-
What is your explanation with regard to the requisition made? Because you
my-
never had a
because
examination being
there are
held.
evidences which shows that there was examination.
No, there is no,
But-
other evidences are there which shows that
My lord,
there was
but
no
does-
examination in this.
Does it prove that, my lord, until and unless that particular
See,
thing
that
has-
circumstance when seen with the subsequent events,
I have not used anything for my own benefit.
Why did you take it then?
My lord, if there was no examination held, can it be for that
See,
405?
the examination was not held, which reads because of the recovery of all the questions. Let's say all the question papers have been recovered.
Recovered.
Why did you do it?
Well, how that
That will have a bearing, Mr.
405, 406, my lord, with my humble submission will not come into it. Because 405 and 406, if the judgment, which ingredients will show, my lord, that has to be used for my own personal use. And after the examination date is over, when I return the question papers, so it is only a scrap paper. I cannot do anything in against those question papers. That has to be used for my own personal benefit. And they have not been able to prove it, my lord, that it has been used for my own personal benefit.
Yes.
My lord, and some judgment, for lordship, I will rely upon, my lord. One judgment, my lord, that is around 60 pages, more than 60 pages, my lord. That is 23. My lord, just
60 pages means what?
my lord, regarding that,
No, no. Why? What is the emphasis on 60 pages?
because my lord, for getting this 60 pages, because I could not take out this printout for it, because that is why. The ratio was about the, my lord, regarding hearsay evidence, oral evidence, and ingredients of 4040. And this, my lord, as regards my lord, here, if your lordship permits me, my lord,
Let us see material exhibit number 1.
my lord, material exhibit number 1. Here, my lord, the certified copy, I have got it. Requisition form. Can I give the certified copy, my lord?
Where is material exhibit number 1?
Not uh, not material exhibit. This is the season list produced by the, where it has shows the requisition form.
Let's find out that material exhibit number 1. Requisition slip.
Requisition form, my lord, with. Your lordship looks into that certificate copy, page 30, your lordship will find it.
Chaudhary, your 313 is that you held the examination. Then how come this question papers were either given or recovered?
My lord, I take it that, my lord, this is my 313, what I have stated, total denial. And my lord,
No, you have given a statement there
I have.
that I had held the examination.
And my lord,
And there are three evidences which people which say that the evidence exam. So now explain the circumstances how these question papers were written.
can I,
You are pleased that the examination was held.
but my lord, whether.
So now explain.
My lord,
Intact. Where from?
My lord, does it, they have proved the 405 and 406? If I have not
We
conducted the
will
exam,
see that if some other evidence, other charge is proved, we'll try to do that.
my lord, here in the
We have the
revision,
power.
my lord, in the revision,
Huh?
my
Why
lord,
not?
your lordship can remand it back for the trial court.
If required, we'll remand it back to the.
My lord, your lordship may.
But for that, I'll have to come to a conclusion.
My lord, for that your lordship has to come. But my lord, they are forgetting it is not on preponderance of probability, it's on benefit of doubt. They had to prove, the burden is on them to prove that entrustment only by entrustment it will not prove. My lord, even my lord, if your lordship permits me, I have gone through one judgment where it says, in paragraph particular, my lord, paragraph 14, where it says that, my lord, by only placing it with me will not prove it. It has to be, my lord, just a small, to make out a case of a criminal breach of trust. It is not sufficient to show that the money has been returned by the appellant. It must be shown that the appellant dishonestly disposed of the same in some way or dishonestly returned the same. My lord, that is,
Everything accepted. You entrusted. Entrustment number is not proved. How many question papers were given? Caesar is there. Caesar, then one of the witnesses, PW10, says that one question paper is less. How? Where is the material to show that one question paper more was given to it? Two, with regard to the leakage would be maybe he has xeroxed, maybe he has done, but that's just a passing remark only. There is no material brought on record to show that the leakage, if any, was on account of the something done by the petitioner hearing. So 405, definition of criminal breach of trust. First part proved, let's say. Second part. He may have done, he may not have held the examination, he may not have done anything. For that, whatever civil remedies follow will follow. But how can a criminal intent be? That second part is not proved. You show me that the second part, how can we hold it to be proved? Either misappropriate or misuse or use in a direction which is beyond the reason for which it was entrusted. Entrustment, let us say it is done. He also will not deny. No, but thing is, whether that was misused. When they recovered it. No, that is hearsay. That is not established. They say everything accepted. Everything accepted. Show me how it was misappropriated. That was recovered. Let us say it was recovered. But he has not misappropriated those papers. He has, at best, what can you do? He wanted, I don't know, that intention is not coming out. But thing is that although he had taken the paper, he had not held the examination. That's the only thing that is proved. Beyond that, nothing is proved. Leakage, it's not proved. It's just a passing remark. Even the trial court or the appellate court have not gone into that aspect. While they have recorded that in the deposition of the witness, they have not gone into that. The only misappropriation now that is proved is entrustment, not holding the examination, proved. How can you? There has to be something more. Mr. Goswami, if you want me to go deep into it, it was just a venture educational institution. He was not to be given these question papers because those students were appearing from some other recognized. It's not a recognized school also. Why did you give him the question paper in the first place? The incident is of? Incident is of
My lord,
2006,
judgment, trial court judgment, my lord,
19 years.
12 years, judgment delivered 2012.
What happened? What do you see? What happened to your service?
He's in,
He is in
Provincial.
service,
provincialized.
provincialized. Any other incident about this man involvement?
Nothing. Time of it, my lord, retirement, I think, my lord.
Now, just tell me, Mr. Goswami, that he has taken these papers, he has not held the examination, whether that will amount to misappropriation. Huh? No. Whether only by not holding the examination can we deem that he has misappropriated? Hmm. Just let us see 405. Misappropriates or converts to its own use that property, or dishonestly uses or disposes of that property in violation of any direction of law prescribing the mode in which such trust is to be discharged, or of any legal contract, express or implied, which he has made touching the discharge of such trust, willingly suffers any other person to do so. But he had taken this question papers for holding exam. Fine. But by not holding, there was no student, so he could not hold the exam. He had to return it. He did not return it. But the thing was recovered. And the Caesar list, you go through. No. That's what is holding me back. Held the examination. Mr. You go through the Caesar list.
My lord,
It is not sealed. It's open cover.
open court. And it was not signed, nothing, it was neither proved. They have only, the trial court held only because of the material exhibit, the requisition form, it was entrustment was proved. My lord, your lordship will find at page,
This is not material exhibit number 1.
my lord, at page 14.
We'll have
my
to
lord,
see
page
that.
14,
Where is that material exhibit number 1?
my lord,
Only the slip. That
my lord,
is not.
here, what it is material exhibit, what it has been proved, saying the requisition. Where requisition shows only, my lord, 15 question papers, 15 students.
Where is that? Where is that requisition?
In the requisition form, my lord.
No. Where is that requisition made by you?
It was not.
Mr. Goswami, just go through the. We'll take it up after some time.
Your Lordship permits me just one line, my lord, in page 14, second paragraph, my lord.
Hmm.
My lord, fourth line, but the learned defense counsel overlooked the fact that there is a requisition slip duly signed by the accused for class 9 board examination. On perusal of the same, I find the said document material exhibit 1 is to be genuine. That is on the basis of which the entrustment has been put.
Okay, let's see. Find it out. But Mr. Chaudhary, 405 would also come in if the entrustment was to be discharged by you in a particular manner.
Particularly,
You have not done it.
my lord. If
405
there is
would
no
come in.
student, if there was no student.
That is a different thing altogether. You were, because once you take a question paper, that means you're holding the examination, not held the examination. Whether it will amount
That will be
to,
a civil conduct, my lord, misconduct in the service, that will be taken care of by the government. But my lord, 405, if some money was given to me to purchase a
get
land,
it, this is also 405.
but,
Here also 405 would come in.
my lord, here,
Because there are many
my lord, but
counters of
my
405.
lord, ultimately, my lord, what
We'll take.
subject,
Mr. Goswami, go through it, let me know.
my lord, then at least at 2 o'clock, my lord, in
Okay, at 2.
some miscellaneous day, my lord.
No problem. Yes, madam, have you found something?
Please, your lordship. Lordship, we a letter to the petitioner lordship. Because want to know whether the person is alive or not, because at that time, the person was 5 years old at the time of pronouncing the judgment. But letter returned to us serving this lordship. We are not aware about that whether
We'll proceed that he is alive.
that triggered, my lord, if he is not alive, then
That is for you to tell me. It's your client, you to tell me. Can this court go and look in his house and say that no, he is alive or dead? Should this court go there?
I'm helpless because
Sir, you are helpless, you be helpless. Yes,
Because
what do
we-
you say?
lordship, before starting lordship, we have 2 context number in our file. We contacted, this number is not working right now. And we took the steps also, lordship.
Fine.
That's the problem.
Thank you for that. Yes. Argue on merits. We are not. Okay. Now, there is evidence on record which says that by mere eye, the currency, whether it is fake or not, cannot be discerned. It required a scientific examination. Now tell me, it is conviction under 480B. Read 489B. 489B, whoever sells to or buys. Now you show me from the materials. The others have been proved by the FSL thing. Show me that knowing or having reason to believe the same to be forged or counterfeit. How is this knowledge imputed to the petitioners hearing? According to you. Because that has to be established for 489 to come in. Only mere Caesar, whether that will be enough to impute the knowledge. Because there is one evidence of one of the witnesses which says that the note on perusal, he's a shopkeeper. It is not discernible whether that is forged or original or something, genuine or something. And also mind you that these people they are villagers, rustic villagers, and they may not have the knowledge also. So that aspect has to be established by the prosecution. Caesar, fine, no problem. I'm not on that. Whether that person had the money, that money with him, he had the knowledge that that was a counterfeit currency he was carrying. Because its wordings are very clear, knowing and having reasons to believe. And that is not for the prosecution, it is on the accused. The accused must have that knowledge. You will have to demonstrate that. How have you discharged that burden? He may also have been taken for a ride. He may also have been the belief that this is a genuine one. If that doubt is there, I'm sorry. We'll have to allow the appeals. Hmm. 7 plus 4, 12. 10, 11, 11. No problem. That is father-in-law and daughter-in-law, right? Father-in-law and daughter-in-law. Okay. Anything more? And the Learner Trial Court has also not examined the aspect. The only inference in this connection is drawn by the Learner Trial Court from the evidence of PW7, a grocery shop owner. That is not enough. But he has not said that he had told them that because of your currency is forged, we are not selling you anything. That's not there. That aspect is not there. He might have said Husura Nai, 1,000 rupees notes. There is no proper explanation. I think enough. 313, nowadays I find that it's only explained to a deny everything. That's not the intent of 313. Anyway, in this, although narrow, but I think the benefit has to go to the. No. When the factum is not proved, why should we impose the fine? It's 489B only. Yes, you want an adjournment? No, allowed. If you want an adjournment, you don't feeling bad for not, I'll adjourn the matter, no problem. No. Peter,
Pleasure.
adjustment. Hmm.
Lordship, the Land Council is in other court. Kindly pass.
Yes, Mr. Goswami, have you gone through the past incident? Huh? But high speed, the other evidences is there is a 40 kilometer. But what is interesting here is PW6, the motor vehicle inspector. He says that the steering had some problem. So if that steering, it's on a turning, this has happened. If the steering had some problem, so the falling of the bus going out of the route is proved that there is a reason. Rush and negligence will not come in. That part. That only PW6 evidence has not been taken care of by both the courts. But he denied 40 kilometers is not that speed. Not that speed. And secondly, the evidence of PW6 failure occurrence due to the failure of the steering. If that be so, Hmm? Or you have not taken that out from the prosecution has not taken that out from the witnesses. And 40 kilometers cannot be said to be rash and negligent. Rash. And if it was in a turning and the bus lost its route, it would be because of the steering failure also. Possible. Okay. Who is appearing in the matter, madam?
Your lordship, Miss R. Rongmei.
Wrong. Okay. Heard Ms. R. Rongmai, learned counsel for the petition, also heard Mr. MP Goswami, learned additional public prosecutor appearing for the state. So the present revision petition has been instituted assailing the judgment and order dated 17/4. Oh, no. Judgment and order dated Judgment and order dated 1/2/2013, passed by the learned session judge Hailakandi in criminal appeal number 22/2012, dismissing the same and thereby upholding the judgment dated 17/4/2012, passed by the learned judicial magistrate first class, Hailakandi, 17/4/2012, in GR case number 166/06, convicting the present petitioner under section 279/337/338/427 and sentencing him accordingly. Also, the prosecution case in brief is that on 24/2/2006 at around 6:30, the present petitioner was driving bus having registration number AS-11-6272, being operated under ASTC by its owner, had driven his vehicle in a rash and negligent manner from Pachgram side towards Silchar, while carrying about 40 numbers of passengers, and while taking a turn at Bagmara Point, the petitioner herein failed to control the vehicle and resulting in it meeting an accident and falling down about 15 feet in a pond near by the road side. It was further projected that on account of the said accident, 22/24 persons traveling in the bus received simple injuries, and the vehicle was also badly damaged. Full stop. The police, on completion of the investigation in the matter, submitted a charge sheet under section 279, 338 oblique 337 oblique 427 against the accused person. Also, the learned trial court, upon considering the materials brought on record, framed a charge under section same, against the appellant herein, a petitioner herein, and the same on being read over and explained to him, he having pleaded not guilty and claimed to be tried, a trial ensued. Also, during the trial, the prosecution examined six witnesses, and thereafter the petitioner herein was examined under section 313 CRPC. Also, on conclusion of the trial, the learned trial court, upon appreciating the evidences coming on record, was pleased wide judgment dated 17/4/2012 to convict the petitioner herein under section same, so and so, and sentenced him to undergo imprisonment, and accordingly sentenced him. Full stop. Subpara. The petitioner, being aggrieved by his conviction by the trial court, assailed the same before the court of the learned session judge Hailakandi by way of instituting an appeal, being criminal appeal number 22/2012. Also, the learned appellate court, upon appreciating the evidences coming on record, was pleased wide judgment dated 1/2/2013 to dismiss the appeal and thereby uphold the conviction of the petitioner herein by the learned trial court, by the learned trial. Also, subpara, being aggrieved, the petitioner has instituted the present proceedings. I've heard the learned counsel for the parties and also perused the materials available on record. Also, the learned trial court, upon appreciating the evidences brought on record, was pleased to draw the following conclusions. Para 13. 13/14. So, basing on the next, basing on the set, it's a basing on the set conclusion, the learned trial court proceeded to sentence the petitioner herein as follows. Issue page 18 of. Full stop. As noticed herein above, the set conclusions as drawn by the learned trial court were upheld by the appellate court wide judgment dated 1/2/2013, passed in criminal appeal number 22/2012. Also, subpara. A perusal of the conclusions drawn by the learned trial court would bring to the forefront that the learned trial court, basing upon the evidences adduced by PW1, PW2, PW3, and PW4, had drawn a conclusion to the had drawn a presumption to the effect that the vehicle in question was being driven by the petitioner herein in a high speed. However, the evidences adduced by PW3, PW4 also brings on record the fact that the vehicle in question was at the relevant point of time being driven at a speed of about 40 kilometers per hour. Full stop. The learned trial court, while proceeding to draw a presumption with regard to the rash and negligent driving by the petitioner herein at the relevant point of the vehicle at the relevant point of time of its accident, had not taken into consideration the deposition of PW6 B.I. Mojumdar, the motor vehicle inspector, who had examined the alleged the vehicle driven by the petitioner after it had met with an accident. A perusal of the evidence adduced by the motor vehicle inspector, more particularly during his cross-examination, would bring to the forefront that the said vehicle might have met with the accident on account of a failure, mechanical failure occasioning to its steering. Full stop. The petitioner hearing during his examination under section 313 CRPC had taken a plea that when he was taking a turn, the steering of his vehicle had got locked and had thereafter broken down, for which he could not control the vehicle, and the vehicle met with the accident. The said statement of the petitioner herein under section 313 finds corroboration from the deposition of the motor vehicle inspector, that is PW6. So, it is a settled position of law that mere driving at a high speed, and that too a high speed, would not automatically mandate a presumption to be drawn that the vehicle was also being driven in a rash and negligent manner. In the present case, in addition to the above position, there being material brought on record which demonstrated a mechanical failure occasioning to the steering of the vehicle, which may have resulted in the occasioning of the accident, and the prosecution during the trial having not negated the said aspect of the matter, the benefit thereof has to be extended to the petitioner herein. Also, in view of the above discussion, this court is of the considered view that given the evidences coming on record, a doubt having arisen with regard to the manner in which the accident has taken place, the death doubt necessarily being required to be extended to the petitioner herein, the same would mandate an interference with the decisions, interference with his conviction under section Arvebal. Also, accordingly, the conviction of the petitioner under section so and so by the learned trial court, while judgment dated so and so, conviction stands set aside. Full stop. The impugned judgment dated 17/4/2012 passed by the learned trial court in GR case number 16606, and the judgment dated 1/2/2013 passed by the appellate court in criminal appeal number 22/2012 stands set aside. Also, the petitioner is set at liberty. You're on bail. He's on bail. He's on bail. Allowed to go on bail after the conviction. The bail on exercise, executed by the petitioner stands discharged. Also, with the above observations and directions, the present revision petition stands disposed of. You can inform her that it has been interfered with. Yes. What do you say? It seems to be a love affair gone. The promise was made by the girl's family that she will be given in marriage to the petitioner, but they seems to have resiled back, for which this whole thing has happened. What is the penalty? 354. 354. Assault is there, but that 354 is not there. One year, 325. 60 days, 350. Assault proved, but 354 not proved. But that is a presumption drawn by the. Just a moment. That's the girl. And that is corroborated by PW5. The brother at that point of time had gone to take a pan. He'll give him probation. Motive is there. And that is only that fire. Disposed of. Disposed of. None appears, huh? None appears below liquidated.
Lord, Mr. Sharma and
Hmm? Why? Huh? There is an interim order operating.
Tail mill, yes, ma'am.
Wait. Fresh bill. 304 part 2. How old was he when in the matter was? 7. Father 70. Father. Have you gone through the evidences? They had taken you up. Okay. On the prayer of Mr. M. Mahajan, learned counsel for the petitioner, for the appellant. Registrate to list this matter again on when do you want it?
Yeah, not in fourth, my
Huh? Other than fourth, okay. Let's take it, buddy. 10.
lord.
And in the meantime, you take your instruction, but I don't think so. That he's alive. Don't kill him.
I did not know, my lord. I was just told, my lord. Right, my lord.
304 part 2. None appears for the petition on call. We'll have to appoint somebody now. Mr. Mishra, will you be interested? 7 years. Can't get a junior. I'll have to have somebody senior here. Mr. M.K. Mishra, learned counsel, on being requested, has consented to act as the amicus curiae in the matter. And a copy DD by her. The court master to furnish a copy of the appeal memo along with its enclosures. Mishra. So registry to list this matter again on when? Give me a date convenient to yourself. Now you are assisting, so I'll have to take your date. 8, I'm not coming. 11. 11 or doesn't hear. 10 or 10. 10. Hmm. Hmm. No, this is revision only. What is the? Hmm. Where is Mr. Goswami? You are for the informant. $324. 2 years. Appeal upheld. No, PW2 is the injured victim. And PW3 also. Hmm? Who died? Eyewitness, huh? The PW2 is the victim, PW3 is the eyewitness. Medical evidence also corroborates. Incident is of 2007. Yes. Chutia, we'll uphold the conviction, but give him the benefit of probation. Otherwise, beautifully done. I think it's under stay. The order is under stay. However, Matiba, whatever Matiba. We'll call it once you need not be here. We have heard you. মাটি দিবা খালি। Yes, Mr. Manav, what is that? Who is the informant? Full injury. The attack took place in the house of the informant. Even three, nothing is there. One month, 047. 23, 3 months. So it's basically PW4 and the doctor. PW1. There was a land dispute. 13 years. None appears for the petitioner. Will uphold and provision. None appears for the petitioner on call. Mr. MP Goswami, learned additional public prosecutor, appears for the state. And Mr. G. Uddin, learned counsel, appears for the respond number 2, public informant. So, the present revision petition has been instituted, assailing the judgment dated 13/11/2013, passed by the learned session judge Hailakandi in criminal appeal number 43/2012, dismissing the same and thereby upholding the judgment dated 9/8/2012, passed by the learned chief judicial Hailakandi in GR case number 63/06, convicting the petitioners herein under section 447/323/34 and sentencing them accordingly. The prosecution case in brief is that what is the name of the father? Nuruddin. Mohammad Hassan Raja Chaudhry had on 1/2/2006. To 2006, lodged an FIR before the police of the before the Katlichara police station, before the before the officer in charge, Katlichara police station, inter alia alleging therein that the present petitioners had come to his house and attacked his son Alauddin, injuring him in his ear with a apostrophe between Bhujali, Bhujali. So it was further alleged that the petitioner number 1 had assaulted his son with a what is the rule? With a stick bullet and injured him in various parts of his body. Also, it was also alleged that the neighbors, on objecting to the action of the part of petitioners herein in assaulting his son, they had threatened the neighbors also. Also, on receipt of the said FIR, the same was registered as Katlichara PS case number 10/2006, under section 147, 149, oblique, 447, /325, /326, /34 IPC. On conclusion of the investigation, police laid a charge against the present petitioners under section 447, /323, /34 IPC. So, subpara. The learned trial court, on appreciating the materials coming on record, had also framed a charge against the present petitioners under section 447, /323, /34 IPC. So the charge on being read over and explained to the petitioner, they having pleaded not guilty and claimed to be trial, trial ensued. Full stop. Subpara. During the trial, the prosecution had examined 5 witnesses and thereafter the petitioners herein were examined under section 313. So, on conclusion of the trial, the learned trial court, appreciating the evidences coming on record, was pleased by judgment dated 9/8/2012 to convict the present petitioners under section 447, /323, /34 and sentence them accordingly. Full stop. The petitioners, being aggrieved by their conviction by the learned trial court, assailed the judgment dated 9/8/2012 before the court of the learned session judge Hailakandi by way of instituting an appeal, being criminal appeal number 43/2012. The appellate court, upon appreciating the evidences coming on record, was pleased by judgment dated 13/11/2013 to dismiss the same, thereby upholding the conviction of the petition. Being aggrieved, the petitioners have instituted the present revision petition. I've heard the learned counsel for the parties and also perused the materials available on record. A perusal of the evidences coming on record during the trial reveals that the victim, PW4, is the only eyewitness, and he had, during his deposition, implicated the present petitioners he has clearly described the assault as committed upon him by the present petitioners. Also, the PW3, who is the mother of the informant, although had not seen the accused assaulting her son, but she had found the accused, she had seen the presence of the accused in their house at the relevant point of time. Also, the evidence adduced by the PW4 victim finds corroboration from the evidence from the deposition of the medical officer who had deposed as PW1. Also, basing on the said materials, evidences coming on record, the learned trial court had drawn the following conclusion. Page 15, red mark. Also, on drawing the said conclusion and convicting the appellants herein, the learned trial court sentenced the petitioners herein as follows. A to A, bottom to B to B. Also, the the appellate court, on the appeal being instituted before it, had, upon appreciating the evidences brought on record, found no infirmity with the conclusions reached in the matter by the learned trial court. And accordingly, by judgment dated 13/11/2013, the learned trial court concluded that the petitioners herein, sharing a common intention, had assaulted the victim after committing trespass into the homestead of the informant with a view to assault the victim. Also, this court has carefully perused the conclusions drawn in the matter, both by the learned trial court and by the learned appellate court. Also, on a perusal of the conclusions so drawn, this court is of the considered view that the same has been drawn strictly has been drawn on a due and proper examination of the evidences coming on record in the trial, and no infirmity is found therein by this court. Also, accordingly, the conviction of the petitioners herein under section 447/323/34 IPC would not mandate any interference. Having drawn the said conclusions, next, this court finds that the offense alleged against the offense committed by the petitioners herein were so committed on 1/2/2006, and around 19 years have lapsed since the date of commission of the offense. Also, the petitioners herein have been also found to be litigating in the matter for the last 19 years, initially before the learned trial court, thereafter before the appellate court, and presently before this court in the present revision petition. Also, considering the long lapse of time occasioning in the matter, this court is of the considered view that the petitioners herein would be entitled to be extended with the benefits from the provisions of the Probation of Offenders Act 1958. Accordingly, for the reasons Baki before the Chief Judicial Magistrate, Haila Kandi. Hello? Are you a fine nine? Payment of fine nine. Dispose of. Ini কেইটামান আছে শেষ কৰি লওঁ তাৰপিছত এইটো মাতিম Yes, Mr. Chaudhary.
Palu, the file ballot, I've just checked up the file ballot. Section 325, my lord. Correct, my lord, and the PSB, my lord, he is no longer there, my lord.
The petitioner is not there.
No, petitioner is there, my lord.
Oh.
The alleged counsel, my lord, Mr. My lord, anyway, my lord. Thing is that, my lord, he has a conviction of they are under section 5. In grounds, I have just checked up, my lord. Here, the heat of the movement, my lord, there was heated exchanges of word followed by something. The injured person actually was
325, 323. Grievous plus as well as
yes, yes. He was sentenced under section convictions and under 320. Now, they actually, the person himself, my lord, they got themselves treated, my lord.
Hmm.
One of the ground, my lord, whether the injury at all sustained because of this, my lord, because of suspected. There, my lord,
PW1 is the victim.
yes, yes, yes. Yeah.
PW2 is the eyewitness
Yes, they are relative, my lord.
of husband and wife.
My lord is already upheld. Five, my lord, the punishment up. And the court also I have seen, my lord. And also try to improve their case, my lord. From the 161 state. But from the record I have seen, my lord. The hospital not being by any police personnel.
But the doctor's injury, number one is fracture, that two injuries. One is grievous, one is simple. That is why 325, 323.
Actually, section should have, my lord, should have been 35, my lord, here. But it is unfortunately, my lord, it should have been 335, my lord. The voluntarily causing heart, 335, that is, my lord, voluntarily causing grievous heart on provocation, my lord. It should have been this section. Apparently, from the evidence, it seems, my provocation, my lord. Not that he has intent that voluntarily.
But that provocation has not come on record. You have not crossed. Three one three is mere denial.
Yes, yes, yes. Well, my lord, the affair itself. It says, my lord, whoever causes grievous harm on grave and sudden provocation, he intender knows himself to be likely to cause grievous harm, my lord. Intention actually to cause grievous harm. Obviously, I think was intention, my lord, he would have taken something else, my lord, in his. My lord, that is evident, my lord. First for this injury or subsequent injury or prior injury, not accompanied by police.
Yes,
then-
sir. Hmm. 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 Who is Sopa Hazarika? No, daughter-in-law, Sopa. Chapa, Sopa. She's also because the not be held guilty under section and accordingly she is acquitted. She was acquitted. Only Siddhiram Hazarika was
The father-in-law.
father-in-law. But there was a quarrel. But initial, after that, that is the defense witness that they had tried to that was finished, then this episode came up. Punishment is incident is of 2010. Too old now. '70. Around. We'll do our duty. No imprisonment. Fine part we are not touching.
Obliged.
Dispose of.
Judgment and order passed in NIA case and by the learned SD. The petitioner was convicted on 38 of the NIA amount, that is 1 lakh and 50. Conviction was upheld by the learned session judge.
Have you paid the compensation amount?
Lordship, as per the pursuant to the understanding between the there was an agreement. Agreement amount of 1,30,000 rupees was and your Lordship,
None had appeared for the respondent. Who is your senior?
That the remaining amount was paid, but there was no as to the so I most
Where do I get that the amount was paid, at least a
Your
part
Lordship.
thereof?
an additional affidavit was filed, Your Lordship. Uh, the B, Your Lordship. Page 8.
Complete your instructions. We'll have it on Friday.
Your Lordship, we have tried
I
respond.
don't want any communication. I want an answer. Because this thing is going on from 2015. Not something which has developed yesterday or today. It is going on from 2015. On a counsel for the petitioner, it's that the question as to whether the balance amount of rupees 20,000 has been paid by the petitioner to the respondent herein. A respondent, comma, has not been received. Thus chance is given to the petitioner to apprise this court, comma, in terms of the earlier directions, comma, as to whether the amount awarded by the learned trial court wide judgment dated 13/12/2011 in NI case number 5/2010 has been paid in full to the petitioner, to the respondent herein. Full stop. In the event the said instruction is not forthcoming, this court would proceed to consider that the amount has not been paid in full and would consider the case on merits by deeming the amount to have not been paid in full by the petitioner herein. Registry to list this matter again on Friday. 31/10.
Right, please. Lord, in this case, for the opposite side, I have intimated on the last occasion, Your Honor. He assured me that he will appear in the court. I submit my part.
We'll have it in the second half. You see whether he comes. The next round, if it does not come, we'll take it up for final disposal.
It
Cannot.
will be day after tomorrow.
Today, why, any problem?
College, my lord.
Huh?
I have the college. I have the college at
College, you are a,
JB Law College.
you are a lecturer there.
Yes.
Will not stop you from that.
Yes.
As prayed for, learned, Mr. V.K. Chopra, learned counsel for the petitioner present, however, none appears for the respondent. So, Mr. Chopra has submitted that he has informed the Mr.
Sir S. Agarwal.
S. Agarwal, learned counsel for the respondent of the listing of the matter today. So, accordingly, a registry to list this matter again on 30 Ali too. Friday, you want it on Friday? On 31/10/2025. Also, in the event there is no representation on the part of the respondent on the next date of listing, this court would proceed to consider the present revision criminal petition on its own merits. Etu 31 now jaga 3 koridia. 311 crore.
Yes, my lord, I have filed a wakalatnama. I have already taken the. I'm actually prepared with item number 8, my lord. So I need some accommodation. Can it be on 24th of November? I'll do it. No, I'll finish it up, my lord. The word I'll do it on 20.
This is 14 matter, Mr. Kamal.
Yes, sir. My lord.
We had accommodated you on the last occasion.
Yes, my I was out of station. My
No,
lord.
they said that your brief is missing. That was the submission made by one Miss M. Begum.
The wrong submission with.
Uh,
We. The
next
team
time
was-
something submissions come up, we will not record
No,
it.
no, my lord. Actually, I don't know how she made this submission. I simply said that we are out of station. Kindly make a mention to. That was my instruction, my lord. Because file is with me, my lord. I was just handed over. Also, I could not be on time.
We'll take it up on 11th.
7th of a bit tight schedule, my lord. Why I said 24 times free.
Because,
Do
Mr.
it.
Kumar, if I accommodate you, I'll have to accommodate everyone.
Then, my lord, on 19, my lord.
You put it before 14th any date.
Well, I'll do it, my lord. On 19, my lord. I give a word, my lord, that
No, we have nothing against Mr.
Well-
Kamar. We know Mr. Kamar.
because these are convenient date, my lord. so I
But
can
the
be
problem
here
is,
with
Mr. Kamar, if I accommodate you, I'll have to
Yes.
accommodate
4
everyone.
days more, my lord. 4 days more, 19, I have a free
Okay,
date. my
on the
lord.
prayer of Mr. Z. Kamal Lanat, Senior Counsel, appearing for the petitioner, registry to list this matter again on 19/11/2025 as a top of the list matter. No further adjournment shall be granted.
Well, I'm sorry, my lord. That
Right.
way, my lord.
Mr. Kamar, your this matter,
Yes, my lord.
how
I'm
long
ready,
will
my
you
lord. I'm
take?
sorry, in the morning session,
Ashok Saikia, how long will you take? 1 hour?
1 hour or
1 hour will do. So we slot you from 2:30 onwards. To 3:30 we are giving you. And before that, we'll finish up the other matters. 2:30 onwards, we'll take up this matter
45 in between, my lord.
for 45 minutes.
Because I prepared, my lord, I'll do, my lord.
Mr. Kamar, I'm waiting to hear you.
No, no,
That's
my
that's
sir.
the eagerness is this side to hear you both on that point.
Just on a psychological note, my lord, sometimes it happens, my lord, I'm physically here, but mentally I'm there. So I want to eliminate that thing. I cannot cope up that, my lord. So once I am free, my lord, I'm before your lordship.
Mr. Kamar, please
I'll
take
come.
your time.
Sure, my lord.
What I said is, if I do it for Mr. Kamar, I'll have to
No,
do it for
definitely.
all.
It's all equality before law, my lord.
That's it.
But actually, we were out of station on that day. None of us were there at that time.
There is nothing here.
My lord, but even
The eagerness yesterday also was to hear that point. That's all.
yes, yes, I will be there. Today I have really prepared it. my lord.
Okay.
I prepared a synopsis also.
That much we do. Just to hear how do you have, what is the law?
Law point is very interesting.
That's what I want to know from you and from Madam.
I have also
How to approach.
Well, just one more line I'll submit. Points, that is one, the consent section. Other is whether 120B simply
That is on the merits of the case.
not merit, but on the charge itself.
Charge
My
itself.
two basic points.
On the charge itself or the merits, whatever it
My
is.
contention is
But
that,
the first point is the one whether it could have gone there.
yes, absolutely. Achho.
What else? Marriage is sustaining now, or there is a divorce.
With respect to your 406, Your Lordship,
This is 406.
498A and 406,
406.
there is annexure C, Your Lordship. Those we feel, Your Lordship. Immanama, Your Lordship. Articles already have. Respect to the gold ornaments and all the thing is mentioned in the Jimma.
This is for quashing.
Yes, Your Lordship. Gold ornaments when police went.
What about 498A allegation?
98.
Let us see.
Maintenance case that has been already settled.
There is the demand, any demand?
But the family court already has
That is compromise between you both. 3,000 rupees per month.
informed by the complainant. Case, Your Lordship.
When was this complaint filed? No, you are not Chandana. This complaint case was instituted when?
2017.
Page 7, page 7. Sometime in 17.
17, your date is not there.
So in terms of that search warrant, goods have been handed over. All.
Gold ornaments already it was with the company. And also it is given, Your Lordship.
Kohana.
Particular it is written here. One act number
Where do I get it?
is number 27, Your Lordship. Serial number 17, it is written.
Page
Page 27, Your Lordship.
of the petition.
Excerpt C.
This is the Jimma articles. Where
Jimma
do I get
articles.
that the gold ornaments were taken away?
After serial number 17, Your Lordship, if act number
For a
8 number হাতত থকা বুলি কয় চেইন সোণৰ
And the respond number 2 has never appeared. There is an appearance. A Deca, A Malakar, A Kulita. Maman, there are somebody appearing, Mr. Esdas and all, but they have not never been appearing in this case. You know them, who they are. Oh, Mr. Burman will know. Just check up. Mr. S. Das, A. Kolita, K. Deca, K. S. Deca is not shown here. S. Das. Just check up with Mr. Burman. If you can get it, we'll take it up. Ingredients of 498A, not there.
FIR and counter FIR, my lord, are brothers. Lordship will find the FIR against me, that is page 10, my lord. And I have come for quashing of that FIR, my lord.
That is under stay. Both the parties are represented.
Fine.
We'll hear the matter.
Page 10 is the FIR, my lord, against us, my lord, lost by the other side, my lord.
Rebuked.
Rebuked,
Threatened.
my lord. Then, my lord, it was registered as under section 290, 323 and 511.
There is no assault being shown here. And the FIR file lodged by you?
So FIR lodged by me at page 13, my lord.
13.
Page 16, sorry.
There is a compromise also.
Earlier, my lord. Earlier.
Anmon-purvak Biniti Nivedan.
That compromise earlier 2001.
This is the 13 is the translated copy
16,
of.
my lord. I'm sorry, my lord. 16. The FIR lodged by me.
$420.
My lord.
What is the stage now? What is the status of that land now? That wall? Then we do one thing. There is an FIR by you also. We are quashing that. And we'll hear because you agree, he has not agreed. So once you have agreed that the FIR is an emotional one, not a criminal intent, we are quashing it. No, by you. You say both the FIRs have been lodged out of emotion. Emotion finds no place in criminal jurisprudence. So we are interfering with that. And we'll hear his thing. Only your thing. And where is 323 coming in page 10? There is not even a whisper of any assault in any manner. So we are quashing this. We'll hear him. You said we'll record that. Oh, 2 FIR and 1 by you. So we remove that 1. We'll consider the 2. Yes. Okay. No. That main fact will come out in the investigation. But here in the page 10, your FIR, I don't find the ingredients of 323. Okay. Hadilana Council for the parties. It is submitted that the matters can be taken up for final disposal. Accordingly, registry to list this matter again on 13/11/2025. An endeavor would be made to dispose of the matters on that day.
Interim may continue. May.
Interim orders, if any, shall continue till the next date of listing.
Replay.
तो दोनों एक साथ, हाँ?
11.
On 11/11, we'll finish it off that day.
Bless.
No, 13/11, huh? 13/11. Both the cases together, huh? Interim order, if any, to continue. There is an interim in your case also? No.
There is no interim.
I have issued the copies, Lordship, as amicus. Here I have gone through the records, subject to corrections. I find one issue was framed by the learned trial court that whether this is legally enforceable debt or not, that your Lordship will find at page 17.
Why is it come up for orders?
I was appointed as amicus to
Oh, that Mr. Sinha's case, huh? That day we appointed, this court appointed you.
This court.
That day it was a top of the list item, I suppose, no? Error case too. Last date Asil Tuma, yes, 15/10, sir.
Then it was listed as top of the list. Thereafter, it was listed in order.
So, Mr. M. Ahmed, learned amicus curiae, has entered appearance on behalf of the petitioner. Mr. B. Sinha, learned counsel for the respondent. Sole respondent? Sole respondent is present. Registry to list this matter again on 3/11/2025 as a top of the list item. That check whether it is a security or a liability.
What I find
What do you find?
legally enforceable debt. Whether that is there or not, that has
to be seen.
properly seen. Because complainant in his complaint petition and initial deposition said that 1 lakh was borrowed from me, and against that loan amount he has issued the check. And subsequently, Lordship, during cross-examination, she admitted that earlier there was a Lordship agreement for selling of a land. For that purpose, she has given 2 lakhs to the Lordship And out of, for that, for that, from the part, as a part payment of that amount, he has issued the check.
Okay.
There was contradiction. So
Okay.
I will just rely on one one judgment of our High Court Lordship.
What is it?
That is Lordship 2018 1 GLT.
Give me the name of the party. Okay. Let me do it. Of top of the list. I don't think.
Prove that how he can rebut that presumption that is there, Lordship.
Okay.
Oblige.
You have some problem. Fourth. Char kar do. Fourth. Yes.
Below. Lordship, this in last Lokoda, Lordship on 14. And in the order dated earlier amount, has not. The case was settled for 21. The entire amount is like.
Yes, madam.
Because without order, they are unable to do that. 5 lakhs has to be deposited. Limit number 2, Lordship.
What is the error, Mr. Agarwal?
That earlier deposited amount is not withdrawn. 21 lakhs. Limit number 1, and out of that, from that amount, 5 lakhs has to be.
You have, the money has not been released to you. 10,68,374. Not released.
Amount is also not released. I know specific order. So
No, because we have recorded here has already paid a sum of rupees so and so to the claimants.
that is deposited not to the claimant, that is deposited for the.
A registry to put up a note with regard to the put up a note indicating as to whether indicating the date on which an amount of rupees 10,68,374 was deposited by the insurance company with the registry. The registry shall also clarify as to whether the said amount has been released to the claimant. Registry to list this matter again on 3/11/2025 along with this said note. We'll have a note and then we'll proceed with that. You also have your instructions by this time, madam. We good? Mr. Das has many matters waiting for.
Many. Oh, now all outstation.
No. Today in station.
Today in station.
So there is some part.
Yes.
So there is
Hearing,
some hearing is going on.
In our Nagaland. You're going to Nagaland. You're right, Mr. Kumar.
I tweeted in this case, the accused was.
Okay, let us go to the
One two-line appraisal backdrop, my lord.
Hmm.
Person were facing a trial, one Ascot Bank
Hmm.
and one a private person. I am representing my lord. They were facing a joint trial and the joint charges were framed.
the other person is no longer in this world, so the matter
No. He was acquitted.
he was acquitted. Sorry.
Acquitted.
Sorry. In this case, he was acquitted.
In this case, he was acquitted, my lord, and I have been convicted under 420 simpliciter. But there is no charge under 420 simpliciter. So it was all along the core case of the prosecution that
120B and
we
420.
conspired, A1 and 2 conspired and misappropriate the money.
That is on merits.
Yes, that is.
You
on
want
merit,
to
but
take a plea
no,
on.
But I am pointing it out on the charge. Merit,
Okay, fine.
when I will show the evidence.
Hmm.
Here I am showing the legal proposition. Because before going into the merit of the case, I submitted that I had 2 preliminary points. And if I can sail on those 2 points, then we need not enter into the merit.
You
Yes.
have your contention is Paltam Bazar police station case, how it got registered with the CBI.
CBI, correct?
What is the basis for that?
What-
You say that there was no notification
Absolutely,
which is required,
correct, my lord.
and in view of that, the CBI could not have come in and investigated the matter.
Absolutely. So
Now, my
about the
first,
whole trial.
first point,
Correct.
was this issue raised before the learned?
Yes, it was raised, it was cross-examined at length, but the honorable learned trial court judge did not apprise that, did not.
He
take
did not discuss that
discuss.
issue.
Neither he.
Can you take
touched-
me to the
Yes, evidence.
cross-examination part, evidence part?
W21 and what is in PW? 20 and 21.
PW?
20 and 21, my lord. Come Nuswa ke list of witness Nuswa se. I'll read the whole, my lord, small, 2021. 20 is the man, Joyram, my lord. He was at that time attached with the Paltam Bazar PS. Today, I have appeared before the court on receipt of summons from the court. I joined Assam Police in the year 71 in capacity of Sub-Inspector Police at Lakhimpur DA. Posted in CID organization from 88, early part of 2003 in the capacity of Inspector of Police CID. CID investigated those cases which are having inter-state ramification. As Inspector of CID, my duty was to investigate the case as entrusted upon me to my superior officer time to time. Apart from investigation, my duty was also to conduct such inquiries as entrusted upon me by my superior officer from time to time. Now the main portion starts, my lord. First para.
Case was handed.
This case was handed over to CID from Paltam Bazar PS. First, it was Paltam Bazar PS, then
Then
it
CID.
came to CID. And I was endorsed. He was with the CID at that time. And I was endorsed with the further investigation of the case since 31/8/98. On 31/8/98, I took the possession of the case diary of this case from Sri Fakhruddin Barbhuiya, the earlier IO of this case at Paltam Bazar PS. I investigated this case till 26/2/2000. My lord, it has become blurred. Madam, can you say 2006 to 2000 some year, my lord? One. And thereafter, this case was handed over to CBI. On the direction of SP CID, BS Bose, then Inspector of Police CBI, took possession. So there was a direction from SP CID. Whether that direction can be constituted as the consent required under Section 6 of the DSP Act will be falling for your lordship's kind consent. This is the line I'm stressing, my lord. On the direction of
You can come to the cross. I think
Yes.
therein the materials are there.
these are not material, but finish only. Now the cross. After going through both the complete case diary of Paltam Bazar PS case number 199, 98 and 202, 98, I am to say that these are not the original case diary of the aforesaid police case which were handled during my course of investigation. So when a case is taken up from his local police, your lordship is aware that they open a case diary. That case diary has to be taken into account, my lord. What were the materials collected? But when he was shown the case diary, then he says that this is not the case diary that I handled when I was the IO. Even after going through the
No, we
complete,
can. Relax.
even after going through the complete case diary of both the cases of Paltam Bazar PS 199 and 202, I state that there is no any notification available in the case diary empowering the CBI to take up the investigation of the case from the CID. Once there is notification, it will be definitely sent to the police concerned, state police concerned, and they will kept it in the diary that in pursuance of the consent given by the state, we are handing over the case diary to the. So there was no notification after going through the whole of the case diary, my lord. Without such type of notification issued by the state government, the state CID cannot hand over the case to the CBI. During my examination in chief in the court, I have also not submitted any such notification of the state government. Even suppose, my lord, during investigation, it was not in
He
the.
says that in this case, there is consent by the state government. I have not exhibited any consent letter in this
Yes.
case. Neither any such consent letter issued by the state government was showed to me in the court today.
Yes. So when they have not seen and it was not laid before the court, trial court, so how will that be constituted that there was a notification to that effect, my lord? Your lordship will see there is some typographical problem, my lord, we will see. In this case, that's important, my lord. So here, the no probably may be missing, I don't know, but since
No, but he says that that was never brought to his.
in this case, there is consent by the state government.
Anything regarding notification wherein the
I
two
have not
cases?
exhibited any
Also-
consent letter in this case and
Okay,
neither.
fine. We have
any
got it. So you can go to the next one, PW 21.
Oh.
So he denies there is any such notification
Yes.
or to his knowledge.
And it was never produced before that, my lord. So now the CID man, Parthasarathi Bose, who conducted the investigation on taking up the matter from A. I'm just reading the first para only to understand it better. I joined CBI in the month of June 83, Central Unit of EO. EO is Economic Offence Wing, New Delhi, CBI. In the year 2001, I was posted in EO, Kolkata, in the capacity of Inspector of Police, CBI. As Inspector of Police, my duty was to carry out the investigation apart from other allied activities on the direction of my superior officer. As and when I took up the investigation of this case on 8/2/2001 in respect of RC 5E and in respect of RCC because of the two case. RC, my lord, you will be aware, this is regular case number such. I took an investigation on 9/2/91. He started his investigation next day 9/2. The name of Ashok Saikia is appearing in the FIR registered being crime number RC5E. After taking up the investigation of this case, I submitted my plan of action, this and that. Now, my lord. Then we'll come to page 4, inner page, my lord, the cross. Because this is his narrative regarding the case, my lord. Regarding the FIR, my lord, it is.
Further examination.
Yes.
On oath.
Yes.
Here
Now,
also
I'm now
there
on
is
the page 4, my lord.
nothing is here with regard to the notification. Now we'll let us see his cross.
Yes. The cross, my lord, are in two parts, my lord. First is by SP Bose by Imran Shah at page 4, my lord. Then down below is the for my accused, my lord.
Okay. Let us see. In Imran Shah's cross also, it is not there.
No, because that was not their point. My
Either
point
in the
was
name
there,
of so
my
and so, no and so.
Now, if we go to
I cannot
page 5
recollect
Ah.
whether I have shown the original notification regarding grant of consent in the. I came to
Depose
depose
in
in
the
court
court.
right after my exam till.
As an IO, I am aware
Under
as
what
to under what manner and under what provisions of law the CBI
take up the
takes up a
case
case from state police. In order to enable CBI to take up a case from the local state police and as per order of the constitutional court or with the request of the concerned state government. That is there, he is admitting. I am also further aware that the state government has to
Delhi
issue a notification
Special-
under 6 of the DSP Act.
It's called Delhi Special Police
Please,
Establishment Act.
they are now.
Delhi Special Police.
Establishment Act. For the time being, if a lordship wants.
No, no, it's okay. We'll go process. Has to issue a notification under section 6. I am also further aware that state government has to issue a notice.
Under 6 of the DSP.
Vis-a-vis Government of India, DOP allegation mentioned in.
I don't know what he said. During the course of my investigation, I have interrogated, examined. Now this is the point that is coming.
So nothing was put to him whether this notification was issued, not issued.
No, I have put it, my lord. That is from there, it is being inferred, my lord. That is their duty, my lord, to show that they are competent.
Okay.
That's my respectful submission.
Further cross is reserved due to want of time. Then the further
That is regarding the merit, my lord.
merit only.
Merit, my lord. On this
Okay.
point, it was at the
So
very
these two
outset.
are the witnesses.
Yes, my lord. I'm
relevant.
just checking out if anything is there. And only suggestion was given that it is not a fact the investment done by Ms. Parveen and not in accordance with the laid down provisions of the law. That is section 6. It is not a fact that I have not applied my mind while investigating the present case of that. So one line is there. It was not in accordance with the law and with the provisions of law. The provisions of law is section 6, my lord. So far section 6 is concerned, there are two witnesses on which it was crossed at length, my lord. And it has come to light that no notification has been produced because
I know. Tapalole.
section 5 and 6 are corollary.
Let us see 5 first. No? Then to any avian. So basically, what is required is under section 6 for exercise of powers under section 5 and 3, that there has to be a consent of the state government. And your case is that there was no consent.
And they have not exhibited and produced any document if it is shown from the record that these cases, originally Polton was a PS case, your lordship will, then it was converted into
PID.
PID and thereafter to CBI RC case. So in between all these things, my lord, there is not a single document submitted before the court any point of time. Suppose, my lord, during the trial, when evidence was being laid, sometime it happens in miss. Even then it being an official government document notification there in the gazette, my lord, the court can be made aware of it also at the argument stage. So it was never done that we were empowered in this.
Any decisions on your
Yes,
this
ma'am.
point?
I have got one directly on the point, but it's from the Honorable Allahabad High Court.
No Supreme Court decision on this point.
Supreme Court are that there, but this one is directly on the point. Page 180, madam. I've taken the printout. Paragraph 16 is the, in this case also suo moto it was done. Like us in this case, if there is no notification, that means CBI has done it. Whether suo moto the CBI can do such thing, but it was with the UPCID, madam.
Yes, sir. Relevant paragraph.
Para 16, my lord.
Para 10.
No, 16(1)(6), my lord. Last part. In view of the above, this court is of the confirmed opinion that when there is a statutory provision to exercise the power and jurisdiction of the members of the Delhi Special Police Establishment Act given under the Act, Section 6 of which does not permit to exercise such power in the state without its consent, the CBI could not have exercised such power suo moto without following the said statutory provision. The Honorable Apex Court is also of the view as laid down above in the case of Sampatlal Supra, because relying on this Supreme Court judgment, that it is a matter where the state police is to investigate the matter. The CBI should not be entrusted the investigation only when there is an apprehension that fair and impartial investigation would not be done by the state. by the state agency. Considering the above facts and circumstances discussed above, the court has to come to the conclusion that the CBI had no occasion to investigate and filed a charge sheet dated 28/12/88 without the consent of the state government under section 6 of the act.
Okay.
So in this case also the similar situation has arisen. So this is the test that is before the court, my lord, my respectful submission that no notification as required under section 6 for that this particular case has to be investigated. CBI. But CBI has got a general notification. The state has welcomed them to come into the state and investigated their
But
subject.
still there has to be a consent given
Consent letter.
for
Because
individual cases.
this is the state subject.
For
the-
individual cases.
Yes. Because why, my lord? These are all police cases. Once you take up a police case, we have to give a consent letter by the state requesting it. And I have got many cases that R.S. Khan's case, my lord, not Kasar Hill, my lord, when it was given to the CBI has taken it up by drawing an FIR at the very instant and with the consent letter. Then there is another case. I have got both the letters, my lord. I'll definitely. How the letter is given, my.
Okay. Next.
That is one aspect of the submission, my lord. The other aspect, my lord, as is one.
No. Anything more to add on this?
Nothing much, my lord. This
Preliminary.
is because, my lord, one thing, had there been any notification, it should have been brought on record. So
Right.
that the court knows, not the accused, let it be. At least the
Okay.
court should know.
So your case is, although the state CBI can investigate a case in the matter, central government general notification is there. But for a particular case to be taken up, there has to be a specific consent given. The word is consent.
Consent.
Okay, madam.
One more line, madam. If the state decide to give a case, then the consent is to be given. Otherwise, the CBI, suppose a bank official is being nabbed, railway employees are being nabbed.
That
because
is central government
the central
establishment.
government, the CBI comes into it. That is. Now, if the state have, we have seen recently due to political reasons of West Bengal, Tamil Nadu, the CBI is barred from entering it. That is their, no, I'm just pointing it out, my lord, to understand the case. But that the state, our state has given the consent. CBI can come and investigate it, but not a police case. Their subjects are different and
Now, how was that consent given? State?
my lord,
How was the
that
state given?
consent is written by the secretary, my lord, through the governor, my lord. I'll show it, my lord.
You have it?
I didn't have it. I asked him, but somehow missed it. I'll give it, my lord. The example model copies, I'll place it before your lordship.
You mean to say there is a general consent already given?
General consent is there, my lord. CBI can, 3, my lord. But in order to take up a police case, the state requests go by section 5 and 6.
So what is that consent then for?
My lord, the state will request the.
No. What is the general consent? What is the nature of that general
General
consent?
consent, they will have it, my lord. And this book is also good, my lord. Manual, all the things are there, my lord.
Yes, madam. Which is that committee? What is that decision? The records. That. Where do I get that notification, madam? You give it to me. Ma'am, we are with you. You just give me that case. What is this FIR number 19998?
FIR, my lord. 199 and 2.
So, Mr.
Fine. I'll come back.
Kamar, this is specific notification here. And when they submitted the charge sheet, they had referred to this.
Now let us come, my lord. Whether it has been exhibited.
Need not be.
No, my lord. Your lordship,
not be.
your lordship, with all respect, I'll submit the, now we are in an appeal. All the exhibited document will only be taken into account.
See, you
Yes.
if that was not done, you should have come up to before this
We
court
didn't
at that
do it,
point
my
of
lord.
that time.
Today, honestly, today for the first time I'm coming it. Otherwise, I would have not raised and wrecked up. My lord,
Along with the charge.
my lord,
Accused, it has been
then, if
It was there along with the charge sheet. I
I-
find it here.
my lord, let us see the charge sheet then. Can I have a look in the charge sheet?
The charge sheet is before the police that no both the cases RC numbers were registered on 8/2/2001 by CBI, Kolkata on transfer of investigation of Paltam Bazar PS case number 19998 and 20298 in pursuance to issuance of notification by the Government of India and Government of Assam for transferring the investigation of both the aforesaid cases to CBI. And the notifications are very clear.
No, my lord, all may be.
These are government notifications. Even we can draw up.
All respect, my respectful submission, whether your lordship accept it or not, that's a different thing. But I'll feeling in my duty. My lord, that these notification were never exhibited in the court. And when I asked the.
You did not ask this specific question
But
to
what
the
my
PW 21.
Yeah, I'm coming.
Hmm? And 21 is the one who had investigated the case.
Oh, that's, yeah, I see.
I am also further aware that the state government has to issue a notification under so and so. Vis-a-vis in the notification never discloses allegations mentioned in the concerned cases. So that is there.
No, my lord, my respectful submission, my lord. This is a surprise to me, this book. We are never served with this.
Okay,
copy.
fine.
My lord, your lordship will accept it or not, but my submission may kindly be taken into account that these are not exhibited documents. It was not brought into the record, my lord. Now from where it is surfacing, I don't know. He has produced it. Now your lordship.
That is referred to in the charge sheet.
Referred to, but not produced in the.
Okay.
Many things may be referred, but the production and exhibition of the document is the ultimate thing. Now, if we again read the PW 20, my lord. I state that there is no any notification.
In the
about-
record,
Ah,
fine,
Is
fine.
the case diary, my lord? Yes, my lord. He has handed over. Once,
memo is there.
how will he hand over? Only when there is a notification.
We'll come to you. Madam, these are the two notifications. Just to take it forward, were these two notifications brought to the notice of the trial court? Where do I find it in the charge sheet, madam?
In the list of documents, we will check.
You just find that out. That'll be the end of the matter.
That may be one good fact. Agree and admit, my lord. Let's see. Otherwise, only with all respect, my lord, exhibited documents, my lord.
And that may be the reason why the court did not think it necessary for proceeding,
Mission are made
burdening the judgment with that discussion.
when the submission.
Madam, just find it out for me. There are other records, but beleg record আছে নেকি? Did you? Sorry, just for a second, just give me that record. এখানে record কিনে দিয়কচোন। এই record কিনে দিয়কচোন।
There, my lord, in the list. The list of the document sheet attached with the charge sheet. There is no mention. No copy was never given to us. No exhibition of the document in the.
There was a earlier writ petition filed before this, criminal petition filed by Imran Shah. On what point was it filed?
Washing maybe, my lord.
Eh,
can.
Criminal revision 72905. I got it.
Reply, my lord.
Okay.
Who is to prove the case, my lord? CBI, not the accused.
No, fine.
Madam-
We'll
Madam-
come to the proof,
Yes.
but the FIR itself, which was registered, this is a public document. And therein there is a reference of these two documents. So we need not dwell into that matter any further.
My lord,
We'll notice your points, but we will not.
my lord, two more reply, I'll
Hmm.
furnish.
That is, copies were also available on record. The copies are there, Mr.
Now we
Both
are-
the copies are here.
Now I'll be just
Hmm. Hmm.
first in the list of documents we checked together, my lord. The prosecution did not rely on that document. One.
Madam, where is that list of documents?
After the charge sheet, my lord.
Nine. I'm sorry, Mr. Kamar.
Fine.
That is an exhibited document. Exhibit number 80.
Let us check, my lord. 80, my lord.
80.
Which document, my lord?
This FIR.
Oh, FIR is there, my lord. I don't
That contains the notifications, Mister.
No, my lord, I get it, I get it. Now I'll submit, my lord. If you're only for 5 minutes, your lordship will bear with me, my. Then I'll close my submission, my lord.
You can have a look at
No,
this.
I know, I'm aware of that. Now my legal contention is that, my lord, on 2 points.
Hmm.
That this was never, the consent letter was never a listed document in the list of documents. No copies were furnished to us.
Hmm.
And my lord, only this much, because otherwise, we I'll be failing in my duty because of the fact, my lord, that a document which is not exhibited in the court cannot be read as an evidence. That is my respectful submission. That's the basic of the, with all respect, I'm submitting my basic of the criminal jurisprudence.
Okay.
That without exhibiting a document in a trial, it cannot be read into evidence. They may have, but it has to be brought on record so that I get an opportunity, so the court can look into it. So these documents were never furnished in the list of documents also.
Hmm.
Your lordship will have a look on that also. Why not in the list of documents? It has been said. Neither any evidence has been read and marked as an listed exhibited documents. A documents which is not exhibited, my lord, then how will I cross-examine on that?
Okay, we got your point.
Because-
We'll consider.
Yeah,
that.
one line further, there is a catena of judgments from the Supreme Court as well as the, is our High Court, my lord. Mere marking of the document is also not amounting to the proof of the document.
Hmm.
Here, my lord, the document itself is not exhibited. That is my contention. So it
The
cannot be read
document
into evidence.
formed a part of Exhibit 80.
Yes.
And Exhibit 80 contains these two certificates. There was no objection with regard to those.
No, because they have not laid that evidence into it, my lord.
No,
Let
they
us see
exhibited,
what is the evidence, my lord.
exhibited
Yes, sir.
80.
I'll
Just
read
see
it
who has
for your lordship.
exhibited 80.
I'll read it for your lordship. What they have said for later, it may be correct, then I'll take.
Madam, who has exhibited 80?
Yes, my lord, I'm going. I owe, my lord. Page, PW 23, my lord, it will be, inner page 3, my lord, probably. 79, I have got it. Exhibit 80, my lord. Exhibit, inner page 3.
Hmm.
Exhibit 80. Compared with the original copy of the original FI carrying Biang number Iman, this was called registered against Khiresa.
Exhibit PW?
PW 21, 22. Ekdam last,
Internal
my lord.
page three.
Yes,
Huh.
last. In the last bottom 5 line, my lord. Exhibit 80. On comparing not a whisper about that, my lord. I read, my lord, on comparing 80. On comparing both the copies of FIR, it say that Exhibit 80 compared with the original is the copy of the original FIR being crime number such. This was registered against Khiresar, Chief Secretary Oliver. The case was entered to PS base. This FIR also bears the signature of Vivek Sai, then SP EOW Calcutta. Exhibit 81 is the same. Where is that notification, my?
81,
81 is the
when
signature.
it was done, it also included these two notifications.
Here,
81.
80 is only for regarding comparison of the FIR.
Fine.
That is nothing is being
81,
stated.
81, 80
No, madam.
bracketed 1 is the signature.
Signature.
And that signature finds place after the enclosures.
That is all there, my lord. Now, in order to bring
Okay, fine.
evidence on record, my lord, there must be specific assertion that this is the notification.
Okay,
My
fine.
contention is that without exhibiting a
this point
document,
we have
it
noted.
cannot be looked into. Yes, my lord, will answer it, my lord. I'll have nothing to say, my lord. That is for that part, my lord. So far, consent is concerned, my lord. Now, my lord. It is not exhibited, it cannot be read into evidence. That is.
This is with regard to maintainability of the proceedings.
My lord, because this was never brought into the record, my lord. Just merely keeping it in the record is not amounting to the proof. Because the court did not have the opportunity to look into. Because court looked into the documents which has been exhibited. Exhibit 8 FIR was compared. Not those notification, not a single whisper by the CBI persons, my lord, that these are the notification. Then the originals, I don't know whether these are photocopy or originals also. The originals of the notification is also there or not, I don't know. That FIR contention was already compared. Was compared between the original FIR, two FIRs. Not the notification.
We have considered your
My-
preliminary. Now let us go to the
Other point. my
other
lord.
point.
Now, my lord, the other point is the regarding the matter of charge, my lord. Page 29. No? It starts from page 27, both the charge date, because a person is put into trial on the basis of the charges framed, as your lordship is aware.
27 of your paper book.
Yes, my lord, of my memo of appeal, my lord.
Okay.
So this is the first charge against the public servant. As your honor is aware by this time, the lordship is aware that there are two persons. One is this Imran Shah, the acquitted accused. Firstly, you Imran Shah being then public servant holding the office of the advisor of Ascot Bank, amount of dishonestly and fraudulently misappropriated by the co-accused Ashok Soikia, and you have thereby committed an offence under 13(2) of the PC Act. So this Imran Shah along with Ashok Soikia.
So it is the criminal conspiracy between Imran Shah and Ashok Saikia
Saikia.
that led to the offense being committed.
That is the thing. Then secondly, you, Imran Shah, being the then public servant holding the office of advisor of Ascot Bank, Guwahati during the said period, committed criminal misconduct by way of abusing and misusing your said official position and power, had obtained for yourself and for Ashok Soikia pecuniary advantage. So I am still there, my lord. So for 13(2) is concerned. Now comes the conspiracy case, my lord. Charged with two head again. This is for the PC Act. I'm not into the picture, but my name has been referred as a conspirator. I hereby charge you as follow. First, that during the period from 18,795 to 7
Reading page 28.
My lord, page 28, right, my lord. First, that during the period from 18,795 to 27,396, with the co-accused Ashok Soikia being that has been cut off, my lord. The Managing Director, Chief Executive Managing Director, Assam Food Products Cooperative Limited, for short AFPPS, located in the premises of the Assam State Cooperative Agriculture and Rural Development, for short Ascot Bank Office Building at Ulubari, Guwahati, and you, Imran Shah, being the advisor of the bank, entered into a criminal conspiracy between yourself in order to dishonestly and fraudulently cheat the Ascot Bank Authority as well as the government by way of recommending for payment of funds belonging to the Ascot Bank in favor of the APFC to be withdrawn by you, the A1 Ashok Soikia, from the current account number 2392 of the AFC lying with the Bank of Indian Bank, Beltola branch, Guwahati, being an authorized operator thereof, thereby causing wrongful gain to you both and wrongful loss to Ascot Bank to the tune of rupees 18,77,900. This is the figure, my lord. And you have thereby committed an offence punishable under 120B. So Imran Shah is charge has been framed that he conspired with the present accused appellant for committing wrongful gain and wrongful loss to the Ascot Bank to the tune of rupees 18,77,900. Then secondly, during the said period, in pursuance of the said conspiracy, you, Imran Shah, being in the said capacity, recommended for payment. So without his recommended, I would have not got the payment of the said amount by way of different checks from the funds of Ascot Bank in favor of Mrs. AFPC Limited, headed by you, the A1 Ashok Soikia, on account of the internal decoration of the office space of Mrs. AFC Limited and the expenditure in the management and society, including the visit of Ashok Soikia to Switzerland. It was never in Switzerland. In evidence, it has come up as France. But the said amount was not returned by the society AFC, and instead of AFC Limited wounded up its business and had removed its office from the premise of Ascot Bank with effect from 1/7/96. You are thereby dishonestly and fraudulently cheated the Ascot Bank, that is Imran Shah, you means Bank Authority as well as the government of Assam, causing wrongful loss to the tune of the said amount. Said amount is 18,77,900. And you have thereby committed an offence under 420, 120B, my cognizance. So this is the joint charge on the basis of which the trial commences. Now coming to my charge, my lord. Next page 29. First, this is Ashok Soikia's charge, my lord, accused appellant before your lordship, that during the period from 18,795 to 27,396, you, Ashok Soikia, being then Chief Executive Managing Director of the Assam Food Product Private Limited, located in the premises of the Assam State Cooperative Agriculture and Rural Development, for short Bank Office building at Ulubari, Guwahati, along with the co-accused Imran, being the then advisor of Ascot Bank, and entered into a criminal conspiracy between yourself in order to dishonestly and fraudulently cheat the Ascot Bank Authority as well as the government by way of recommending for payment of the fund belonging to Ascot Bank in favor of
Just a
AFPSC.
copy and paste. Only the changes
Yes.
in one.
No, my person's name, correct, well. So
We got
here,
it. The allegation you are trying to project, Mr. Kamar, is that it's not only against Ashok
Yes.
Saikia. There is an angle, starts with Imran Shah, benefit flows to Ashok Saikia.
no, both,
But I'm saying
They say
benefit flows,
in the chart.
but Ashok Saikia has done it. But the action of Ashok Saikia is by itself not complete if there is no cooperation from. We got your point. We got your point.
And one more, just one more, madam. So here it is 120B simpliciter to Ashok Saikia for conspiring with Imran Shah. I have been acquitted from there. Now the next charge, my lord, only that is important, I'll read it. Your lordship gets me in the.
No, it's fine. Read it.
Just reading, my lord, to show that during the said period in pursuant of the said conspiracy, you, Imran Shah, being in the said capacity, recorded for payment of the said amount by way of different checks from the fund of Ascot Bank in Ashok Saikia on account of the internal decoration. So for decoration, check was given to the office space of AFC Limited, and the expenditure in the management of the society include the visit of Ashok Saikia along with PW5 that has been not written to Switzerland. But the said amount was not returned by the said, so if not returned, my lord, then there is civil case will appropriately die for the recovery. And instead of AFC Limited owned up his business and have removed his office from the premise, we have shifted our business, not removed. On 1796, you are thereby dishonestly and fraudulently cheated Ascot Bank Authority as well as Government of Assam, causing wrongful loss to the said amount, that is 18,77,900, and you have thereby committed the offense of 420 and 120B. So against me, there was no 420 simpliciter charge.
120B.
120B is all along. First 120B, I have been acquitted. So under 420 rated 120B, I have been charged now, but there is no charge simpliciter under 420 IPC. That is my respectful submission. So for the things is concerned regarding the conspiracy angle. My lord, we have segregated as to that part and have prepared the to the best of the ability we have prepared. My
Mr.
lord.
Kamar.
My lord. So that I'd like to hand it over to your lordship, because whether a person.
No, Mr. Kamar, before we just for the benefit of this court,
Sure.
what is the conclusion by the learned trial
Yes.
court towards excluding Imran Shah from the
Yes.
whole?
That they could not, prosecution could not prove.
Where is that?
Yes,
That
that part is
material?
at page 52, it starts, my lord.
Hmm.
Then, my lord, if I'll show the shocking part, my lord. Because to read that para, my lord, we'll have to read it from big para, 24 number para, my lord.
24.
That will start from page 51. But the main part is at page 53.
24.
It's the whole para I'll devote, my lord. I'll.
No, it's okay. We have
Now,
gone.
53, if your lordship will look into the question that has been asked will be replied at page 53.
Hmm.
From the evidence of record that has been established beyond reasonable doubt that accused Saikia cheated Ascot Bank as well as government, causing.
You're reading?
I'm reading from 53, my lord.
53. Okay. You can just come to 52.
My lord.
52 after the learned special PP middle. Also
In
relied on case. In the case on hand.
It is revealed from the evidence on record that Ascot Bank allotted fund to Assam Food Product even before its registration as society, and also fund was allotted subsequently. So it was Imran Shah who has done it. When the member of FL was sent to France, because in the charge it is Switzerland. Here now it has come to France to study producing of soya meal, came back and formed an opinion that the scheme was not feasible here. It was a business venture. It did not materialize. For that, there is no cheating, my lord. A business venture is not always successful. It sometimes may go haywire, my lord. There is a clear evidence on record to show that Ashok Saikia dishonestly induced Ascot Bank to allot fund to APL for installation of soya milk industry and subsequently by not returning the money. It was a joint venture of Ascot as well as the cooperative society. The proposal made by Ashok Saikia to the Ascot Bank for giving rupees 10,73,000 even after forming an opinion after returning from France that the scheme would not be feasible clearly shows the dishonest intention. That is completely wrong appreciation, my lord. Of accused Ashok to cheat Ascot Bank. He has not taken for personal gain, my lord. He went there to study the feasibility along with PW5, one Mr. Jain, who was the CA of the society, my lord. Ashok Jalan. At that time, when proposal for 10,73,000 was made by Ashok Saikia on behalf of FL, he was sure that the venture of installation of soya milk industry of Assam would not be feasible. Malak, without visiting any place, not making any study, how will a person be acquainted that it will not be a feasible way into the venture, my lord?
Now, Mr. Kamar, this is the only material which is there.
No, my lord.
This is the part of the conclusions
basically.
drawn.
But the evidence, if you're.
About that I want to. What I want to know is, what is the basis of this conclusion, evidence?
Yes.
In relation to this, Madam will also show.
Sure, definitely.
So now what I understand is that although there was a conspiracy angle against Imran Shah while the FIR was filed, there can be. But from the evidence, the learned trial court came to a conclusion that, okay, this amount you got it for going to France. You went to France. You came back with the opinion that this is not feasible in the state of Assam.
After studying it.
But in spite of that, he made a proposal for 10,73,000.
No, for the whole, my lord.
No, this is after returning.
For what, my lord?
To cheat, at the time when proposal for was made on behalf, he was sure that the venture of installation of. So I just want to know when this proposal was made in relation to his visit to
After
France.
France, my lord.
Hmm.
So after France, my lord, this
If it is
evidence, my
after
lord.
France coming back, then it will have a different connotation.
So
if it is
this-
before,
this-
it will have a different connotation.
Definite. So, so far I remember, my lord, by reading the evidence, my lord, it is the reimbursement bill. They went on their own, and when they came back.
Just show them.
That I have to show it, my lord. I'll have to look into it. Now, why this man was.
So this is the only thing
thing.
against you, the whole thing.
No.
So just establish whether this is prior to France or after.
Coming back from.
Madam, you can also just examine that. This is the only thing left now.
Well, from the evidence I've taken is assistant, my lord. I did not check it, but it is said that no date is mentioned, my lord, when the opinion was given.
We have checked.
The proposal. No, where is that document with regard to this? Which is that?
PW2 net 3.
And what is the evidence in support of that? Let us see if there is some evidence discussed. I think it is in para 23.
The judgment. That he has tried to put the blame on me, though his opinion was on a Imran Shah proposed the chairperson that the amount of 10 lakh separately be released subject to execution of an agreement by Managing Director, Assam Food Products Cooperative Limited, and clearance from the retainer lawyer of the bank. But there is nothing in the record to show that before release of 10 lakh 73,000, any agreement was executed by Ashok Saikia and any clearance. So it was the bank who paid, my lord. And taken from the learned retainer, it has been submitted by the learned defense counsel that had Imran Shah been involved in any conspiracy with Ashok Saikia, he would not have imposed condition to release the final payment of the equity share of the this amount. Accordingly, to me, there are grounds in this submission, so he was acquitted. So giving the money is the discretion of the bank. Can I read one evidence regarding the?
Just a moment. Yes, Mr. Kumar, you can proceed.
Just pointing out that figure, my lord, if your lordship will see in the cross of PW1 for Imran,
Yes.
PW1 cross, my lord.
Mr. Kumar, your argument is that without Imran Shah being roped in, implicated, you cannot be roped in. So this court has to examine as to whether there is an independent action on your
Yeah.
part without the backing of Imran Shah with regard to release of 10,73,000 odd. That much only.
That, for that, your lordship has made a pertinent query, my lord. Now, if your lordship will see that whether the charge was framed for committing fraud of 1877,900, my lord. Page 23. The judge himself was not clear that whether there was deflection and cheating of an amount of which amount. Lordship will kindly have one as page 53.
53. Yes.
53, the first para, last line.
Hmm.
The court says, my lord, the trial court says, from the evidence on record, thus it has been established beyond reasonable doubt that accused Ashok Saikia cheated Ascot Bank as well as the government of Assam, causing wrongful loss to the bank and government of Assam to the tune of rupees 10,73,000 or 1877.90. My charge is for committing a cheating of amount of rupees
What is
80.
the difference between those two? It will be around 8-9 lakhs.
Yeah, well, so no, my contention is that, my lord, I must know for what I am charged and what I am facing. Right.
Got it.
So judge, while writing the judgment, even after conclusion of the trial, cannot fix what amount has actually been cheated. So he has come to a figure of or, my lord. That cannot be, because I have to be on reasonable doubt. So that is one leg of submission. Now coming to your lordship's query, my lord, that this proposal, my lord, nothing has come into the evidence on record, save and except one line, my lord. That amount of 10,73,900 is not for payment of anything. It is for the share, my lord, because it was a joint venture. I am reading from the inner page of last page of PW1, the cross examination made on behalf of Imran Shah.
PW1.
Yes.
Where are the exhibits kept? It's kept along with this only.
There will be a separate file, my lord, maintained with the list.
Madam,
of
okay.
documents.
Madam, just find out exhibit 5 for me. Yes.
I never dealt with the file of Assam Food Product Limited. The Assam Food Product had purchased the equity share of Ascot Bank of rupees 17 lakhs. As per the note sheet exhibit 5.4, the MD of Assam Food Product requested for sanction and payment of 10 lakh 70.
Sorry, Mr. Kamal, I'm sorry to disturb you. Where you are reading
From
Vinod Talukdar.
PW1. Yes, my lord. The last part, my lord.
Of?
Last page.
Last page. Of his chief.
Yes, my lord. No, this is crossed by PW1 on the top.
Okay.
Last page, my lord, before PW2 first page.
Crossed by PW1 Imran Shah.
Yes.
Hmm.
On oath, I never dealt with the file of Assam Food Product Limited.
Hmm.
Assam Food Product has purchased equity share of Ascot Bank for rupees 17 lakhs. As per note sheet 5/4, the MD of Assam Food Product requested for sanction of payment of rupees 10,73,900 for equity participation of Ascot Bank. This is the proposal that you have purchased the share, now you pay that amount. So it was nothing to do with that going.
That's why I wanted exhibit 5.
Fine.
The advisor, you can read further.
Then, my lord, The advisor put a note to the chairman stating that he may agree to the proposal as submitted by CED in charge and GM in charge. Gaps and a decision of the board of the EC subject to execution of agreement by the managing director of Assam Food Product Limited and clearance of the learned retainer council of the bank before release of the final payment of the equity share. The chairman Srimati H. Saikia has agreed to the said proposal on 7296. In Exhibit 5/3, there is a note stating that they receive an application from Assam Food Product furnishing budget of 1996 to 31,396 and requesting the arrangement, the fund of rupees 10,73,009,000, and they have also sent a copy of the equity share received from the bank in 2C. But in the file, the said equity share is not available at 2C. There is a note sheet 5N on Exhibit 5 that 5.8 regarding share of Assam Food Product of 17,33,900. It is that amount, my lord. That is the share amount that they will be a participant joint venture. In Exhibit 5, the resolution of the board regarding participation of the Ascot Bank in Assam Food Product is not available. I am not aware of it as that time I did not deal with the file. In Exhibit 5, there is no indication that any legal opinion from the retainer lawyer as proposed in Exhibit 5 probably was obtained. In my statement before CBI, I never referred to the note sheet made in Exhibit 5. I only stated about the instrument of payment. So for the first time, he deposed before the court and he has stated that this amount was for in lieu of the equity share buying. So it was never
So we'll have to see what Exhibit 5 is.
5-4.
Just show me that. No, Exhibit 5 would be,
The whole file. 4 is the relevant part.
and where is the application?
Sir.
Exhibit 5. Okay, I got it. Okay, where is the board resolution for this of Ascot Bank? Because this is with regard to investment. If we take it as an investment, there has to be a board resolution. We got it. We got it. The other body. Chairperson. Yes, Mr.
Now, my condition is that when there is on charge of 420 cheating, simpliciter, my lord. So I cannot be convicted under simpliciter 420 because the charge itself was under twofold, 120B IPC where I have been acquitted, and another was 420/120B conspiracy. Both the sections or conspiracy was there. In
We got it.
yeah, 421. So without there being a charge of simpliciter, there
You cannot be.
one. So
Anything you
therefore
want
that-
to, just to get over that conclusion of the learned trial court, you want to show something more in
I'll show.
addition to PW1?
Definitely, I'll show, my lord. But just the legal proposition, if your lordship will have a look, the Supreme Court judgment, my lord. 1995, my lord, it's a small judgment, my lord, para 4, my lord. Shall I read, my lord? Para 4.
Hmm?
I know submit.
Just make a note, madam. When you argue, just place it.
There has to be another with whom the get in communion conspire for the commission of an offence. Here the 7 accused who are so charged for being in conspiracy with the appellant may be either by the trial court or by the high court. This judgment is on that ground, my lord. When there the conspiracy charge fails, the very foundation of the case fails. That is the
That is your plank.
my prime argument, and that is being supported by an authority, my lord. So it is legally not feasible or possible to maintain the conviction of the appellant for offence punishable under 120B IBC, for the appellant was never charged of having entered into a criminal conspiracy to commit the said offence in conspiracy with person other than those named person who have been acquired. To maintain the conviction of the appellant merely because he was in charge of the telegraph transfer section on such premises would therefore be difficult, though his responsibility otherwise to the amount in question cannot be minimized. Leaving apart that aspect, it is not to be forgotten that we have only to determine herein the guilt of the appellant. On the failing of the charge under section 120 BIPC, the other offence loses their roots, as without the aid of 120B, it cannot be spelled out or deduced, even though the appellant stands directly charged for specific offence with and without the applicability of section 120B IPC. We have not been made wiser by either side as to where from can we spell out the complicity of the appellant to the loss of money which the bank has suffered on account of the fictitious and forced telegraph transfer, more so in the absence of any person being charged of the offence from mailing branch of Madras. In this situation, we have no option but to allow the appeal, set aside the conviction, and
This is your basis.
yes, my lord.
We
My
got
case, my lord. So, my lord, other points, my lord, what I say, my lord, in the charge head, after filing of the charge sheet, my lord, the court takes into account, as a lordship note, that after hearing both the parties, either the charge or framing charge, so the charge is the main thing for the trial, my lord. If the charges is wrong, my lord, for that also I've got a judgment in the form of main pal, my lord. Yes, I'll continue. Para 9, that the accused must know the exact charge for which he is being tried. The lordship got it, my lord. Page 5 of 7, para 9. The following principle of section 212, 215 and 4 of the code relevant to this case becomes evident from the said inaction. The object of framing of the charge is to enable an accused have a clear idea of what he is being tried for and of the essential fact that he has to meet. The charge must also contain the particulars of the date, time, place, and person against whom the offence as are reasonably sufficient to give the accused notice to the matter which he is charged. So it has been done, my lord. But the accused is entitled to know with certainty and accuracy the exact nature of the charge against him. And unless he has such knowledge, his defense will be prejudiced. When an accused is charged with having committed offense against one person, but on the evidence laid he is convicted for committing offense against another person without the charge being framed in respect of it, the accused will be prejudiced, resulting in failure of justice. But there will be no prejudice on failure of justice, and there was an error in the charge and the accuser aware of the error. If there is error, that will not wipe out the offense, my lord. Such knowledge can be inferred from the defense, that is, the defense of the accused showed that he was defending himself against the real and actual charge and not of an erroneous charge. In a judging question of prejudice as of the guilt, the court must act with broad vision and look to the substance and not into the technicalities. And their main concern should be to whether the accused had a fair trial, whether he knew that he was being tried for, whether the main facts sought to be established against him were fairly and clearly, and whether he was given a fair chance to. These are the inaction, my lord. Now coming to my case, my lord, what were the charges? I have dissected and found it can be dissected in 5 broad principles, 5 broad points, my lord. I'll deal it one by. I have prepared my lord written argument to the best. Of course, with his
That will be
assistance,
very
my lord.
helpful, ma'am.
I tried, my lord. Page 5,
Said
para
and
eight.
done, this activities relating to ASCA be closed
Well,
down.
at that time, it was one of it, my lord.
That's a very good
Bank made for a good purpose,
purpose, but can't.
but it was not fulfilled, my lord. Otherwise, had it been professionally managed,
Have been a different thing.
leading bank, my lord. It's a very noble cause. It
Was
was
done.
in page 5, paragraph 8 of my written. I have tried to dissect it, my lord.
Just a moment.
Now that money was taken for decoration purpose, nothing, no evidence led. Expenditure in the management. of
Boils
the-
down to that 10,73,000.
Yes, now the judge himself was not sure at the end of the trial that whether I have cheated 10 lakhs or 17 lakhs. So there must be beyond reasonable doubt means what, my lord? So without any ambiguity, without any doubt that I have committed the offense of cheating of rupees 10 lakhs or 17 lakhs. The judge himself, the trial court judge convicting me doesn't.
But the only thing which I find subject
my-
to
my-
further,
I
your
try to
further
answer.
going into that. Here, the Ascot Bank, as a bank, when you know it's
Yes.
a cooperative bank, so the board of directors would be the authority to take
Absolutely.
decisions.
No doubt.
But here we don't find the board of directors being roped in. It was all done by the managing director,
Managing director.
who was also the managing director in your organization.
No, he is not our member, my lord. But
Yes.
no,
No.
certain persons were lent
No,
to
no,
us.
no. The managing director of Ascot is also the chairman or managing director of your organization.
The mother.
Mother. Okay.
But that I'll be not pressing because she is not an accused in this
And
case.
that the Learned Trial Court has also,
Say.
somewhere it has said.
Say. But coming now to this aspect, my lord, that regarding the charges that has been framed against me by dissecting it. on account of
Mr. Just
Come on.
that you are here now. Just to pick out from you,
Yeah, my lord.
just want to learn.
My lord, how it
There is a charge sheet filed. A charge sheet, police investigation charge sheet can be of any nature. But the ingredients, if it is there, and the court finds that, okay, you have given a charge sheet, CBI has filed a charge sheet of conspiracy. Now, the Learned Trial Court had excluded Imran Shah from the purview is only because of 5-4 note, wherein he said that you execute an agreement and take an opinion from the retaining counsel. So this aspect maybe have weighed on the
it seems so from the
it
judge.
seems from that it weighed on the Learned Trial Court,
Fine.
and the Learned Trial Court proceeded to acquit him. Now the Learned Trial Court examined the matter and found that the buck moved from you to the mother, and this was done. The contrary argument that was raised was that because the CEO or the advisor had advised, it was on the basis of the advice of the advisor Imran Shah that this was brought. The learned trial court, on the basis of the evidence, culled out that no, this offense is only limited to this aspect. And she is not there, so we are not bringing her. But your complicity was brought and the implication was there.
According to the trial court.
In that circumstance, if that is the evidence, without this case, everybody was set out because there was a requirement of a nexus in your decision that you relied. Here, your independent action that you have taken brings on record commission of an offense under 406 or 409, whatever it is. Will it be erroneous for the learned trial court to ignore that and say that no, because you framed a charge under 120B 420, we will not go by 120 because 120 not proved, 420 also we will not examine. What would be the approach of the trial court in this kind as an officer of this court?
My lord, to be honest, I'll submit 2 3 out here. If the trial court found that I cannot be convicted, there is a simply
I'll just dilute.
just give it.
The conspiracy angle is gone.
No, gone. So the charge ought to have been amended. It's curable because till the writing of the judgment, we have seen a time again, my lord, that while writing the judgment, what your lordship said, it has come to the supposed to the trial court mind. So his utmost duty was to change the charge and then to proceed with it. Without changing the charge, my lord, because now I am being misled by this charge that I am conspired with that man. If that man goes, I also go because it is he who has given it. Save and accept that note of 5-4. Exhibit 5-4. Now,
I'll put it in a different, just for me to understand, nothing to do with this.
I'll try, my lord.
There is a case of wrongful restraint and say 325.
Marpit.
Wrongful restraint led to, first wrongful restraint has to come and then the marpit will come. Now the court finds that he was moving, there was wrongful restraint is not there, but 325 is proved. Whether amendment of charge would be called for?
I don't think so because there is a direct evidence that Marpit took place and he was assaulted. But here in our case, the core case is that.
No, that is what I'm trying to understand. Here the evidence that has now come on record shows that you have put up an application for 10,73,000, be it equity, be it that, be it anything. You have put an application for 10,73,000. This went to the
Chairman.
No, the chairman. Chairman put it up before the advisor. Advisor put up a note on a particular line, but that was ignored by the chairman and the amount was released to you. Now here there is direct evidence. The only note conspiracy is 5-4, right? 5-4 is the only conspiracy note.
That for his defense, otherwise he is doing everything, my lord.
Either as it may, but here now, because you are there, we'll have to look in from your prism.
My view.
So 5-4, if we take it out and hold, that 5-4 actually was not complied with. The
Now-
conspiracy was not with the chairman, with the advisor, but with the managing director, who was the same authority in both the organizations. In that view of the matter, if that evidence is culled
That
out,
evidence is not on the record. First.
that's what I'm asking you. I was asking you. If that is culled out, whether 420 can be brought against you.
My respectful submission that since I have been told that you are being charged for committing an offense along with Imran Shah for conspiring and taking.
Okay.
That is my respectful submission. And the most important thing from the very outset, the core case of the prosecution is that we both, because the IO's evidence I have.
It is there.
It is there, my lord. So now the other parts, my lord, that I went to Switzerland, that is not in evidence. And the expenditure in the management of the society, no breakup has been given from where all these things has come. Just a lump sum has been said that I have cheated the bank either of 10 lakhs or of 17 lakh. And as your lordship knows, my lord, very well, that the case of a criminal case is to be tried beyond all reasonable doubt. So here the judge himself was in doubt, my lord. So what amount was actually cheated? That is my respectful submission, my lord. And even the cheated amount in the second charge, my lord, 420, 120 BIPC, the amount itself is not mentioned. Because after all, conclusion of the trial, that figures ought to have surfaced, my lord. What was the exact figure? For a loan amount, then
Okay,
why?
Mr.
Right.
uh,
Sure, my lord.
Kumar, it all boils down to this 10 lakh 73,900. Now, this 10 lakh 73,900, how is it equity?
My lord, that is they participate into our management, my lord.
If you go through that, 10 lakh 73 has been broken down as capital interest, capital expenditure, already expended, and revenue expenses. And it says it is 10 lakh 73,900. It's not with regard to the how many shares you are buying, how many shares you have already
It was
brought.
probably 51 and 49. Is it?
It was 5 lakhs and 1 lakh 50,000 earlier, 6 lakh 50,000 earlier. Now, where is this? Only as equity shares so far purchase of bank is also. Yes, please put up necessary orders, so and so, so and so, so and so. Any evidence that how this money was withdrawn after you had
My lord, by
released?
yes, my lord. That
Which
evidence
is the
coming,
relevant
my lord.
evidence
Yes.
witness here
Yes, sir.
for that?
My lord, that breakup is given by PW1 and also by PW2, my lord.
W1 and 2.
Okay. Two, I could see it in page 2, my lord.
He is a bank employee.
At page 2, if we read, the portion is there, my lord, third para. The exhibit 26 is the check credit challan of Indian Bank, Beltola Bank for clearing
Page,
check of
page,
women.
internal page?
My internal page 2. Of 17,795 for 5 lakh and the said amount was credited to FL. This amount was deposited at the time of opening of the account in the name of FL. But this date, if your lordship will see,
Just a moment, I've not found that.
my lord, page 2, second para, my lord, exhibit 26.
Exhibit 26 is the
Yes.
check credit challan of Indian for clearing check number so and so, and said amount was, this amount was deposited at the time of opening of the account in the name, in the signature of the clearing office. Are the
Here-
transactions challans respectively all are credited so and so? Are the checks of so and so issued?
We pause and submit, my lord. That these days 17,795 is probably one day after when the period has been taken, my lord. 18,7 is the period taken for my offense, my lord.
And one more query.
Fine.
We'll hear you. Sorry for disturbing you. Just trying to clarify.
Pleasure, my lord.
Mr.
I like, my lord, when the court interacts, my lord. And
Mr.
some tough questions, my lord.
No. Mr. We can't. put
Honestly,
up
I'm saying
to
so, my lord.
Mr.
No, my lord.
Kamar
No,
at
my lord.
least. This is a doubt created, so I just want a clarification. Mr. Where is the evidence on record? Is there any evidence on record that these transactions with regard to share was beyond the power of the authorities?
I don't find it, my lord. Honestly, it will be half part, my lord.
Not there. That this, it is not there.
Not there, I know, but it's.
So you mean to say, is it your case that the materials that are there, that this investment actually is an investment in the equity? Huh? If that be so, okay, fine. That would have a different connotation altogether. But if it is an equity investment, why this big Allah? It may be fraudulently got, but still it's an investment made. And I find in the note of the Imran Shah, the 5-4, that there was an approval of the board of directors also. If that be so, why this big facade been created? Where is that allegation that share certificate has not been given? You show me. Why was the FIR filed in the first place? That is what I want to know. What is that irregularity you basing on which you filed the FIR?
First thing, in the FIR, 20 other persons were named. That has come on evidence or record. No investigation to that part. None of the person has been charge sheeted.
No, with regard to the present thing, Ashok Saikya, where is the material? No, reimbursement of the amount, if not given, that would give rise to a civil nature of dispute. Madam, you have the evidences with you. Kindly go through this. Now you know the mind of the court. These are all tentative views. All tentative views. I'm still not satisfied by Mr. Kamar's reply with regard to the conclusions drawn. I'll hear him further. But I want to know from you that we are not going into, madam, that Mr. Kamar is arguing. Will, if required, if it comes to the hilltop to push, we will use that. Otherwise, we'll not. We are in the merits. We are on the merits. Now, show me that if you accept that this is an equity participation, this is not a loan, this is an equity participation. It went bad. It would give rise to maybe civil proceedings. What is the criminality involved here? Because it does not say that document 5 does not say it is for setting up of a soya plant. Although the breakup therein is for that. That is there. This is the. No, for where is that? 16,296 is only equity participation. That you find out. In after 16.2, madam, after 16.296 or before 16.296. You check that. You check that up. Mr. Kamar, I think we stop for today. We have got your points.
Because the loan which your lordship has clarified it is also written in the judgment that it was never sanctioned as a loan amount.
It was equity participation. If we go by 5.
It says that I failed to return the money. If I fail to return the money, my
No,
lord,
no,
you
if
need-
it is equity participation, you need not return the money.
No, that's the company's participation. So I'm saying that the judge said that I did not return the money also.
That we will look into it. But
Why I've
the,
been convicted?
the heart of the judgment is that part only,
Yes.
page 23 onwards.
Yes, absolutely.
Okay.
Now I've given my written statement. There is the, just if your lordship has taken so much of note, 213, AS in the BSc.
Section
Illustration B, 213 illustration B, probably it squarely covers my case, my lord.
under section 230.
CRPC earlier, my lord. 213, when a manner of committing offence must be stated, the illustration is given, my lord. So if we come to illustration B, A is accused of cheating, B at a given time and place, the charge must be set out in the manner in which A cheated B. So the manner of cheating has not been stated. Whether by equity or by loan, nothing has been brought into the
No,
record.
it's not a loan. It's a equity participation. Because everybody is relying on 5.
Yes,
Exhibit 5. If
Five.
exhibit 5 we rely, it's a equity participation.
absolutely. So while I have given that note,
You have given. But Mr. Kamar,
yes, my lord.
just to take me out of that conclusion drawn, and just to take me out of para 23 onwards
Of my lord,
hmm,
of the judgment.
of the judgment, with specific reference at page 52,
My lord.
that you read out in the case on hand.
In the middle, allotted fund. to
Funds. So these two are the only
hindrance.
hindrance against you.
I'll try to.
So kindly find out any
sure.
evidence that you have that will take you out. And madam, just to solidify those 2 pages, if you have anything, just find out that for me. No, we will look into it. No rush. It's waiting from 2013, 12 years, no rush. Another 2 days will not make
Sure.
any change. Because now I have got it, I'll also go through it once. Monday.
Well, I have prepared the list of PWs, which PW has stated,
Oh, that would be great.
and the legal citation. That will give a glance, my lord, which witness is deposing on what point. And if you're one important fact.
Haddi Lana Council for the parties at length. Haddi Lana Council for the Mr. Z. Kamar Lana Senior Counsel, assisted by Mr. Deb Chaudhary. Your P. Deb Chaudhary, learned counsel appearing for the petitioner, has made his submissions in the matter. However, the same remains inconclusive. Ms. Devi, learned standing counsel, your retainer counsel. Retainer counsel, CBI, is present. Registry to list this matter again. Can we take it up tomorrow, 2 o'clock?
I'll go through it. Actually.
Tomorrow. Okay. Whenever.
Well,
Monday?
I think one good day I'll suggest.
Monday?
But
don't take a-
Saturday we have a court day, my lord.
Very good. Saturday.
That will be very nice.
First.
Only
Oh,
I
very
can-
good.
I can-
Saturday. I'll ensure Mr. Kamar is here.
I'll be here, but of course, my lord, I'll, front of all, I'll confess one thing, my lord. We are daily laborer, so we have to hop in.
After you have the Mr. Kamar,
My lord.
after the hand is elongated,
Yes, my lord.
then you are a daily wage earner only. We'll have it on 1/11/2025.
111.
I'll run through the list on that day. Whatever is there, some urgent matter, we'll take it up. or we'll consent.
I'll be here for the full day, my lord. There's
No, we will not
That's why I
permit you to
stipulated
have
that date, my lord.
this spend.
About the sir.
Huh? Madam, just find out these things for me. You have not got the area we have culled out. If it is equity, what I'm against you, if it is equity, then
শুনিলো না আগে কি কইছে
no, madam, whatever it is, if it is equity, how do you proceed with that? What are the materials? What is the evidence to dislodge that view? And he will support that it is equity.
On the contrary, I'll support. My lord, the manual, your lordship will keep it.
No, you can take it. God only will knows where it will go. Thank you, Mr. Kama. This is a learning experience.
So I'm also getting.
Both of you. It's a learning experience for me.
He is a veteran on the prosecution. side.
Madam is a,
Veteran, my lord.
but
Right
what
from
I
the-
like about her is she's so soft spoken.
Yes, yes.
But she puts it very affirmatively.
On the
On the
bullseye. I will take leave, my lord.
Thank you.
Much of.
Yes. Arosani. Huh? Miss so-and-so, assisted by N. Chaudhary. Chaudhary, Learned Counsel. Written a counsel likha na? Uske baad assisted by Miss, along with Miss N. Chaudhary is present. If there is something like this, just let me know so that I can incorporate. Yes, Mr. Chaudhary.
Full cases, my lord, only entrustment 405 will not do, and para 47 of this judgment, my lord. Lord, since you want 18 STC, page 70, my lord.
No, here's something. Yes, Mr. Goswami. But the other part. Will be too much. Then the question would be, why was it handed over to him? Because his school is cannot hold an examination. Mm. No, the school students will go to that center. It will not take it from here. Yes, which is the evidence? PW10. Okay. Posimpoka Center. Because that is the recognized school, maybe a provincialized, maybe something, it is a recognized school. This school is not recognized. This is a venture school. But there is evidence that this school is a provincialized school. Not a provincialized school, it was a venture school. No, that is not there. That is a presumption we can draw. And we can also draw a presumption contrary that he should not have been given this. PW10. I'll go through it. That is only a slip. Where is that list? No, where is that list? Oh. MR 206. MR number 206. Where?
Lord, I am giving the copy. Here it is, my lord.
Just about that.
There
Before
was a
that, 206. Okay. One original requisition form written as 8 Koregaon Pathar Anchalik HS, description as total number of candidates subject wise and medium wise in the school. Students shown as English 15, MIL 15, General 15,
15.
General Science 15, General Mathematics 15, Social Science 15, History 5, so and so, signature by Mohammad Mohiruddin Ahmed, Headmaster, so and so, dated nil as per school seal. One notice copy regarding return of annual examination, that is that he has not returned. Now, where is the Caesar? Material exhibit 3. Let us compare it. First is English. So English 17. But here the English was only 15 students.
Mathematics also 15.
MIL, and what is the paper that was said to be lower, one less?
That is mathematics.
Mathematics.
It is 15 number of students.
Mathematics. Number is mathematics. Total 16 number of printed pages, 2006 question paper with cover, 2006, 16 numbers. Now,
Students 15.
how many students are there? Mathematics.
15.
One extra came out. How? They give it in weighing. So this conclusion that there was one less is wrong. So you just show me if there is anything here which shows that he received so much of papers. That is nothing. Not there. So he did not hold the examination. That is a different thing altogether. Whatever punishment, departmental action you can do. But the misuse of these papers are not coming forward directly. That has to, because this is a case. I was trying to find out I was trying to poke Mr. Chaudhary to get something out from him. That is why but this is there. Nothing is there. It is by force conclusions have been drawn. We'll acquit him. Circumstances will not come here because when you have the direct thing, see, 405 is the requisition, entrustment. And the misappropriation now, because the non-holding of examination is not misappropriation. Misappropriation would be the question papers seized. Now, whether there is any evidence, there is another aspect here also. If there is categorical evidence that from his school, these question papers got leaked, that would have been helped, but there is nothing. It's just a hearsay by somebody. The direct evidence is not there. Somebody heard. The person from whom it was heard, he was not examined. Secondly, if the number of question papers which were given to him and the number recovered, there was a variation, then we could have said, yes, he has misappropriated one, conviction perfect. But that is also not there. Because for that, you will have to establish that these were the number of papers given. We can't draw a presumption there. Well, no, I got it. But Mr. P.K. Chaudhary, Learned Counsel for the petitioner. Also heard Mr. M.P. Goswami, Learned Additional Public Prosecutor appearing for the state. Hearing remains inconclusive. Registry to list this matter. 1. The Chaudhary will now come on first. Saturday. No, first. If you are not there also, I've just passed the order. You need not be here. I'll pass the order. I'll just put it for hearing. Sir Chaudhary, I'm not troubling
No,
you.
no, no, man, I will come.
No, no.
It will be a pleasure to have
No.
a cup of tea there.
No, 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 no. We, no. I'll pass the order. You need not be here. I'll record your names. Don't worry about it. We will record. But I'm acquitting him.
Obliged.
Because they are today fully tied up. I don't want to put them on more pressure.
Obliged.
Mr. Chaudhary, it was real fun.
No, my lord, but I also learned something, my lord.
No, I learned. I was trying to get things out from you. And this judgment, judgment of whom I will take.
Para 47, man.
Yes. Item?
60.
None has appeared for the. There was somebody in the morning. Ratiba kun nasil na? এইটো আমাৰ কোনোবা কাৰোবাক এপইণ্ট কৰিছিল নহয় প্ৰথমবাৰৰ কাৰণে আহিছে নেকি None has appeared for the petition on call for the ends of justice registry to list this matter again on 1 তাৰিখে লৈ লোৱা 1 তাৰিখে নিদিবা এইটা শুনিব লাগিব ন এইটো দিয়া 1 তাৰিখে দিয়া 1 তাৰিখেতো নাই বেছি মেটাৰ এইটো চলিব এইটো এটা সৰুহে
For information,
Mr. You are Mr.
R. Kumar.
Our learned counsel for the petitioner is present. However, there is no representation on behalf of the learned, on behalf of the respondent. So, registry to the Wakalatnama filed on behalf of respondent number 2 reveals that along with the councils whose name are reflected in the cause title, Learned Counsel as thus was also engaged as was also name of as thus was also involved in the said Wakalatnama as a counsel representing the respondent number 2. Registry to list this matter again on 1/11/2025, reflecting along with the other counsels for the respondent the name of S. Das advocate.
Half of UK, but
S. Kumar,
R.
R. Kumar,
R. Kumar.
R. Kumar. You are enough for us. Thank you.